Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Good morning, everyone. We're just waiting for Linda to appear, but I thought I would get it up since the fan is up. Thanks for joining us, and thank you for your patience.
Welcome to the stage where stories unfold. Linda and Michael with courage so bold. To be the poodle and dominoes flare. Together they bring justice with care. Thank you for joining the JSTV ride, where truth and logic collide worldwide. Legal analysis with a flair so prime. Justice Served TV, it's your time. From courtroom drama to truth untold, each case of mystery and answers to unfold. With wagging tails and a steadfast team, justice prevails. It's more than it seems. Shadows may linger, but light will reclaim. Decoding the puzzles and solving the game. Law and heart, a powerful stream. We stand together in this JSTV dream. Thank you for joining the JSTV ride, where truth and logic collide worldwide. Legal analysis with a flair so prime. Justice Served TV, it's your time. Linda's sharp mind and Michael's find. Together they untangle justice's bind. With 2B and Domino on the quest, fighting for what's fair, they won't rest. Linda's sharp mind and Michael's find. Together they untangle justice's bind. With 2B and Domino on the quest, fighting for what's fair, they won't rest. Tuned in trial's on display. Linda and Michael guide the way. Mascots hopping, dominoes fall. To be spinning, let's answer the call. Justice Served TV, get on your feet. The court's in recess, feel the beat. Legal fire with rhythm alive. Dance it out with justice jive. From the bench to the floor we groove. Commentary sharp and smooth. In the courtroom or on the stream, we break it down while chasing the dream. Oh, Justice Served TV, get on your feet. The court's in recess, feel the beat. Let the mascot spark the lights. Dance through the trial, ignite your nights. Break it now, no time for objections. Spin it now in all directions. Linda snaps a fact, Michael's on the move. With justice jive, it's time to groove. Witness the rhythm, vibe in session. Trial watching turn to a confection. Mascots jive and jurors sway. Thanks for being here today. Break it now, no time for objections. Spin it now in all directions. Linda snaps a fact, Michael's on the move. With justice jive, it's time to groove. Witness the rhythm, vibe in session. Trial watching turn to a confession. Mascots jive and jurors sway. Thanks for being here today.
As the Commonwealth rests, now it's our stage. We start to turn the final page. With truth and facts, our case begins. Defending rights, so justice wins. Let the evidence speak, let the facts unveil. In this trial of truth, we shall not fail. United we stand, with courage unfeigned, till justice is served and integrity gained. David, Ellen, Liza, Bob, and Victoria proclaim. Free Karen, read the core of our aim. With voices united in harmony we stand, seeking justice across this troubled land. Let the evidence speak, let the facts unveil. In this trial of truth, we shall not fail. United we stand, with courage unfeigned, till justice is served and integrity gained. With truth on our side, no need to hide. In the courtroom where justice will abide. Facts laid bare with clarity and might. We march forward, guided by the light.
I'm here, everybody. Half made up. I don't have my makeup on great, everyone. So bear with me if we're on, or if we're not on. If we are on, or if we're not on. It was really confusing, wasn't it, this morning? I mean, I'm rushing here because initially we had it, I know, as 9:20 because that's what she said. But then court had started. But then what the heck's happened? So you're going to have to bear with me because I'm not made up. As a matter of fact, I need to put my glasses on, but I had to rush down because Diz called and said, wait a second, where are you? Where are you? And I'm like, well, court was supposed to start at 9:20, you know. You know, I was working on a rant, which we're actually going to do at the lunch hour now. Thank you very much to say I look great. The shirt yesterday was actually, if you're talking about yesterday's, that was our, and I have it here, that was our new Justice Served TV hoodie, right? Which was this beautiful, beautiful lilac and pale peachy salmon pink and green. And all designed by Diz, okay, and just gorgeous. This morning I'm just in plain white because when you're rushing, I mean, it was just the simplest thing to throw on. Okay, but yes, Shy Gal, that was great. Thank you very much for being with me. I was like, whoa, am I here? Am I not here? What the heck is the court doing? You know, we had a rant yesterday. Today at lunchtime, I'm actually going to do one, and it's going to involve, and maybe the men won't like it, but I think our audience will. The issue of, I think, the sexist, not only the sexist prosecution, and I'll say it, I started by talking about it yesterday a little bit, you know, with a person like that, which totally offended me. And I felt like a juror. I really thought about it. And I felt like a juror that when a witness says something that turned you off, you get turned off, right? You get turned off. And I was turned off with that, just really turned off. And so today I was thinking about it all night. We were having dinner with a client last night. As you know, I had to leave you and let Michael Bryant, who was, you know, 12:30 in the morning where he was, take over the show. But I understand. I saw the clip. You had a great show talking about the buffer zone. And one of these days, maybe John Matus will be a co-host with us on the show when we need a co-host because he was terrific and he's from that area. And also, I loved watching it earlier this morning and bringing you that content. As you said, where in the world we were broadcasting from where in the world. I have to crack up because Michael Bryant's on time at midnight where he is, and I'm here not on time. And all I have to do is get dressed and walk down the stairs to, you know, I'm not actually in the TV studio right now, as you know, that I have here because I'm having a little radio frequency interference problems. And so I have to get an electrician in to figure out what the heck is going on with that, because electricity is one of the things I don't like to fool around with and I don't like to touch. So, and yeah, so that's I definitely want a professional. Let's see, who should I call? Judson Welcher? No, I'm not going to call him. But I would call Stephen Plord. If you didn't see our show last night, Stephen Plord, accident reconstruction of 45 years, mostly worked with the police. He said, yeah, and he knows Welcher. He says, you know, he didn't go far enough. The reason why he didn't go far enough is he didn't have any data to go far enough with, and he thought it was ridiculous that, you know, that he did things that would confirmation bias, that would cement what he thought. You know, it would just cement what he thought. And he said, when you're getting paid that kind of money, you know, you're giving to the prosecution what they want to hear. Stephen was so honest. He's so great. He's so honest. And at the very end, we're going to clip some of the things to play over the weekend. So if you don't want to watch the whole show, you can watch various clips at various times. He said there's simply not enough evidence to convict her. And this is coming from a man who spent most of his life in law enforcement and who's just an honest accident reconstructionist. Honest. And I know you all loved him and all. And we're going to actually have him on again when the ARCA people testify. Whoops. I think maybe I'm in time for court. Unmuted. All right, let's go into court. Let's see what is happening, if anything, important. Helpful to the defense would be nice.
Now opening ATV.
I don't know if I heard what she said.
Thank you. So I was told counsel want to see me at sidebar?
Oh, we have a sidebar. So did I miss anything? I don't think I missed anything, right? I missed anything. Let me just check. don't think I missed anything. I'm here with you, and that's all I care about. That's really all I care about. Let me make sure I didn't miss anything. Okay. All right. No, but we are going to, again, as I said, while we're doing this, we're going to have, before the defense begins their case. By the way, it was irresponsible for another network outlet to put on that the defense has to prove now it's going to prove their case. Defense has to prove anything. They don't prove anything. All they have to do is present evidence that will poke holes in beyond a reasonable doubt. This is not an affirmative defense where someone's saying you're insane or you're self-defense. Those have proofs by the defense. This does not, and it's irresponsible to say otherwise. The state has the burden of proof, and that burden of proof remains in that jury room until the jury decides that they have met their burden beyond a reasonable doubt. All right, and to suggest that the defense has any burden of proof is, I'm going to say it again, irresponsible. And I actually put something up on Justice Serve TV this morning. I should have put my initials on it because I hadn't consulted with Michael Bryant, but I know he would feel the same way. And we have said here in this network, this is a burden of proof case. You may think she did, you may think something, you may have predilections about it, but for people to say that defense has a burden of proof, wrong, and more wrong. Not only wrong, come here, we'll set you right. Now, I'm having a bent on this case. My bent so far, if I were sitting as a jury, is that they haven't proven this case beyond a reasonable doubt. Period. End of discussion. And Welcher cemented it for me. And remember, the prosecution case was as good as it gets when they rest. That's the best case scenario. That's the best they're going to have. All right. Now, I know Hank Brennan's trying to say things for rebuttal. He thinks he can rebut some of these witnesses and bring things for rebuttal. And well, we shall see. And I think what he wants to rebut is he wants to rebut what we know may be coming, which is Chloe the dog. That these are dog bites. And there was also something very interesting, a slide somebody was posting on the internet. I'll talk about it afterwards. And it had all of the findings of the autopsy report. And it was an eye opener, but there was nothing presented by testimony in court, but it's all over Twitter now. And it talks about how Mr. O'Keefe had an 85% occlusion, I believe, of his lower anterior descending artery, the widowmaker. That's what people just drop dead. That's severe heart disease. Now, I don't know if that factors in here at all. Obviously, the defense, the prosecution aren't using it, but it was a shocker to me to see it this morning. I didn't retweet it because I don't know if it was one of those slides that passed by and somebody took a screenshot of it, but you can go find it on the internet. It was a shocker. It was truly a shocker. So how does that factor into something? If Chloe the dog attacked and somebody has a heart attack, and then you say, oh my God, there's somebody dead in my house. These are hypotheticals. I'm not saying this is what happened. Okay. Bring the person outside because you don't want a dead person in your house. I mean, we've seen that not in drug cases where somebody drug overdoses in somebody's house and they're found way out somewhere else, and then someone says, how did they die? Because they're found somewhere else because somebody dumped the body because they didn't want to have him in the house. To make it account, Linda, does Dr. Baden suggest proactive testing for those predisposed to heart disease? I have no idea. Okay, I have no idea. I know. I mean, when you have annual physicals, it seems to me they give you, as you get to a certain age, they give you stress tests, right? And all. So I simply have no idea. But it was a shocker to me because it was never asked about other findings when the medical examiner was on the stand and all. So I don't know why. Maybe there was an agreement between the defense and the prosecution not to go there. I simply don't know why. Sam Poop, cardiac ICU, RN nurse here. I was surprised. So was I, because we all know what that means. I mean, I had a bookkeeper in my office back when I had the office in the gallery in Red Bank. That's exactly how he died. He just dropped dead. I mean, he just dropped. And I think the autopsy revealed he had something like an 80% occlusion. That's when you get stents put in. Everyone is familiar with that. I mean, how many people do you know in the world that have stents? I've seen people in their 30s and 40s get them because your arteries are occluded. So, I don't know how that figures into there, but it seems to me that if you didn't want, again, they're into this Higgins, the defense is into this Higgins and how to fight. But then again, that could indicate, why somebody in the middle of, having words could have fallen down backwards and all. It seems to me that the defense would have been, maybe they had their theory, and there's reasons they have their theories. But I mean, you could be in somebody's house and get into it with somebody or a dog, and then if you have an 85% occlusion rate, drop dead and then fall backwards and hit your head. And there could be nothing nefarious about the actual death, but the nefariousness is about whether or not you cover up the death. Now, I'm not saying that's what happened. Okay, I'm just saying that's an alternative theory that I thought that I'm thinking after I saw that the defense could have pursued, and maybe there was a reason they didn't. But that just happened in passing. I didn't see the slide. I only saw it last night when I came back and was surfing the internet and playing our replay with Michael Bryant and all, and John Matus and Jason Grant, who, as you know, we were talking about what people can now do in the buffer zone. And you all can go down there if you're there in the buffer zone, as long as you don't wear Free Karen Read shirts. You can say, dissent is American. I support the United States Constitution. We're here for the Constitution. You can say anything like that. The government sucks. Anything like that, as long as you don't have a free. It's not one side or another, free or anti. And then this applies to both sides. Okay, and so they can be in the buffer zone. They can be congregating in the buffer zone. They can be doing anything in the buffer zone as long as they're not protesting with Free Karen Read type stuff on them. And that's Erica Walsh, who won the microdots, the drop microdots merch store sweatshirt. She can wear that, but she can't wear the Free Karen Read heart. Probably the same went for Mr. Delgado, except for the fact that, you don't rip things off somebody. You just ask them, in this world, you ask them to take it off. And so hopefully even the state police will reveal that maybe this is a good idea. Okay, Shy Gal, new member, you're always supporting us, Shy Gal. Thank you for being here. Also, look at my rant from yesterday. I on the one of a person like that, I really feel very strongly about it. Olivia Lambo was in our chat last night, and she thanked me for the rant, and she said it was appropriate and needed to be done. And I asked you to go look at it. Because I think when you start degrading witness a person like that, it's one thing to have a difference of opinion with people. It's another thing when somebody's getting paid $400,000 to come in and act as if you are, greater than God. We had said the night before.
Start with the required finding argument.
Okay, there you go. I think we're going to have some ruling, maybe on the motion to dismiss. Let's see. Let's go to court. Let's listen.
So I'll hear you whenever you're ready, Mr. Jackson.
Thank you, Your Honor.
Sure.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth is simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scortibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there's not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind him. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably.
You just heard a closing argument, by the way.
Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
That's a closing argument, by the way. That's the basis of their closing argument. You just heard it. In the last trial, she did not allow these directed verdict motions, as we tend to call them, to be made in open court. Now we're going to hear Hank Brennan.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. The reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just 2 of the cornerstone pieces of intoxication, which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
Judge Beverly is going to deny the defense motions. I can tell you right
Motion
now.
is denied as to all three of
Yep, I told you. Then he
them.
just
The
got
other
it in
topic
there.
We were discussing it sidebar. I don't need to hear argument on that right now, Mr. Yannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So we ready to bring the
Okay.
jury?
I told you that was going to be done, but what you're hearing basically is closing arguments. I'm talking over Judge Cannoni because it's about ready to start. I got it in there before she said it because I know she doesn't even give a reason for it, right? She does. I denied. All right. You know, and that's normal. That's what usually happens in cases. It's very seldom that a case gets dismissed at this point. Judges don't like to do that. But those are the arguments. Basically, these are the two cases that side to side. It's a closing argument from the defense and a closing argument from the prosecution. That's what you're going to hear. Okay. Really interesting that just as we talked about on the show, they brought Dr. Wolfen to say, oh, well, if he'd gotten treatment, he would have lived. Oh, give me a break. Okay. So they're imposing that kind of recklessness on her. He's kind of admitting, Hank Brennan, that you don't need to have intent. The intent is by the fact that she was drunk and therefore she knew or had a reasonable, plain and strong likelihood that that death would occur. That's how their statute of murder reads, by the way. All right. But you saw how dismissive she was. Now, apparently there's something else that's going on at sidebar that Mr. Yannetti brought up. And then she says, you and Hank Brennan talk. But we expected that. Those of us who are lawyers expected that. But, you heard AJ, and it was nice to hear his voice again, quite frankly, wasn't it? Wakes you up in the morning. There's not a single incident to the event that said that there was a collision. And in fact, Jennifer McCabe, busybody, who watched the whole time, she never saw a backing up and a hit, right? She never saw that. So that is interesting that they're going to have to use her as one of their witnesses on the basis that maybe she didn't want to cooperate with anybody because she did not want to help Karen Reed for alternative reasons. But there you go. That's the argument. AJ said that there's evidence that I put him Higgins and Albert, that Higgins was love struck, that he wanted to have a relationship with Karen Reed, that he coaxed John O'Keefe out of the house. So that has to do, I think, with the third party culpability, because he, as recall, way back when the judge said that it was hanging by a string and she'd wait to see what was produced before she decided whether or not the defense could rely on third culpability. Okay, who could rely on third party culpability. So that was that was the issue of Higgins and Albert. Now, she may dismiss that. She may say, no, you can't argue that in your closing. Just so you know, that's the next thing that could easily come up here. Al Jackson made a fine argument, just as we said. The medical examiner is the only one who had hands-on of John O'Keefe. All right, that was her duty. The prosecution called the medical examiner so he can go at her on redirect. Okay, he can go at her on redirect. As he did trying to demean her, and the same with Wolf. Same with Wolf and Welcher. I hate to talk about Welcher, but she didn't mention him too much by name. But obviously, we heard him. And that stupid recreation. Now, Stephen Plourde last night, our accident reconstructionist. We asked him, "Have you ever, put on the decedent's clothes?" He said he has, but not in this type of situation. They normally will buy a decedent's clothes and then they'll wear them, or he wouldn't do it. He'd have a surrogate do it, but they buy it in an issue where there's an issue of visibility. Could somebody hit somebody? Could you have seen that person? So they'd buy the decedent's clothes, get a surrogate to wear them and put them on, but not in a case like this. I have to tell you, in Hernandez, we did buy a shirt of a decedent, an exemplar shirt, and because we had found a exit bullet wound hole that the state was saying was just a regular tear in the fabric, that the medical examiner concurred with us that it was it was an exit wound, and our medical examiner said it was an exit wound. And so we had a student, a law student, in the courtroom for a demonstrative exhibit, and was wearing the shirt to be able to demonstrate how the shot went one way and came out the exit of the shirt. And for that, we had to use the exact same shirt, because you had to show that it moves the same way. You had to show the fabric was the same, because or else your recreation is not as scientific as you would like it. And it was demonstrative, but there was no disrespect intended there. Here, I know a lot of you felt kind of disgusted by it, but it was interesting that Stephen Plourde said they would get a surrogate to do that, but not in this type of case usually. Usually it's in accident reconstructions where you're seeing a visibility here. And he said, here, look, they did what they needed to do. I mean, he knew what the result of this was, and we don't know how many times they practice it, back up 2 miles an hour. And the other thing Stephen Plourde said, look, you're talking about a breakup out of a light. You have to do, it costs you $400 to buy the lights. You go buy 10 of them, and you do the hit of the light with a crash test dummy or something that has that type of same weight, whether it be the arm or the body of John O'Keefe. And he said also, even if it was hit the way Welcher said he was hit, that he wouldn't end up with the back of the head. He would be in a twisting motion, a turning motion, and end up at a different location. So Stephen was just excellent, and he knows Welcher, and he told us when he thought Welcher was doing the right thing, and he said he didn't go far enough because he didn't have any evidence. So he just said, okay, I'm going to stop here, and this comports with what the person who paid me says it did. So it was really a wonderful interview. If you haven't seen Stephen, he was really wonderful. We're going to have him back next week. And speaking about somebody who has no dog in the fight, he has no dog in the fight. He spent his whole life mostly with the California Highway Patrol doing accident reconstruction. Now he does mostly civil cases, some criminal defense on a private basis, but 45 years. and honesty. 45 years and honesty. Okay. And so I think you really should look at it. And quite frankly, if the Commonwealth were interested in what really happened here, they would have gone out and hired someone like Stephen Ford. All right. Not someone that was going to bill them this kind of money. And by the way, I think experts should be paid. Okay. I know my husband gets attacked sometimes in the stand. You've been doing something for 60 years. You're going to your own doctor. How many times we go to our doctor and the doctor says you can leave and it's like $1,000 bill. You pay it because they have the expertise to do it here. But there was a case that somebody brought up that the court disallowed his review of medical records, $16,000 from a review of medical records. Why? Because he's not a medical expert. And while you have to review some of the records to see whether they're relevant,
unmuted.
The court disallowed that. The court in Massachusetts also disallowed one of his opinions because it had to do with corpse testing, just like it had here, a 50-year-old study that the court found was inappropriate, improper, and wouldn't allow his opinions in. But this court, no problem, no Daubert, no problem. And experimental grease paint. And blue, by the way, if you want to talk about sending a subliminal message that you're supporting the John O'Keefe supporters, get blue grease paint, all right? Why not pink grease paint or orange grease paint or yellow grease paint, okay? All right. Anyhow, I have by the way, my Apple Watch on, something that he wasn't allowed to look at yesterday. Okay, while the judge is doing those three questions, we're going to hear from Matthew DiSogra, the defense, a new crash daddy, as we say, and he's going to talk about how Shannon Burgess, I think, data is phony, because he's going to talk about what the data really means. And we're going to have to listen very carefully. It may seem boring, but it's not boring, okay? But it's not boring. This is incredibly important.
And as you know, the defendant has absolutely no burden of proof in this case.
There you go.
I have to try a case, but I hear that you are. So your first witness, please.
She should say, however, they're just presenting evidence. They have no burden of proof with the evidence, okay? There we go. And I see
Matthew DiSogra.
Okay.
Alan Jackson getting up. So we should have a fun day, okay? Welcome back, Alan Jackson, my adversary inspector, who I got the hung jury against and who I have enormous respect for. Welcome back. I'm going to be behind the Tubi avatar, but I'm still going to be here with you. So if you see me behind Tubi, don't worry about it, because you know how Tubi tends to chime in with his barks on this case. Okay, Matthew DiSogra. As we said, defense matters was our theme for the day. Matt DiSogra.
The evidence you give the court and jury in the case down here is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
All right, Mr. Jackson, whenever you're ready.
Thank you, Mr. DiSogra. Could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DiSogra, last name DiSogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction. And within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data, and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does EDR services mean?
So, event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing. So we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please finish.
Ultimately, anytime we're doing EDR or data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're. Mm-hmm.
So Lexus is a Toyota brand. Right?
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So that's it. It's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit. What about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so we're analyzing that data. Most of that's GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them. So we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota Lexus versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle. then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems and many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead.
Oh,
the road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
And you have a Master's?
Correct.
In engineering?
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed, in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you regularly attend symposiums or symposia, I guess is the right
Yes.
word? Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? I'm sorry, have you attended data? Have you attended events that deal with data, event data recording systems and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level. And then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am, active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I am currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization, within the organization of the Society for Automotive Engineers?
I am. I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does. And it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year, published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components. It's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have an infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So, you know, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. And we demonstrated we could basically do it ourselves if we wanted to.
Mr. DiSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval?
Yes.
How many times?
Once
When was that?
in New York.
You were deemed qualified as an expert in that court in this field that you're talking about today.
Specifically with as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes,
Are you familiar with Aperture?
yes,
Before you were asked to undertake that review, were you familiar with Aperture?
yes,
Were you familiar specifically with Shannon Burgess?
yes.
Were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Miss Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you in fact review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2, 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events. So we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event?
For the 1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to my-
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained is to form.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the jurors so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Objection.
Sustained as to form.
Is there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that
That's
long.
my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long,
Right.
correct?
Correct.
So in other words, it captures, or does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event,
of the recording event.
not
So,
the trigger.
correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate. I'll withdraw it. I'll ask it a different way. What would be the effect of timing if you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shannon Burgess's, the time offsets that you identified in Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Objection.
Sustained, ask it differently.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question. With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection.
Sustained.
May we approach, Your Honor?
Yes.
This is ridiculous that she is sustaining these objections. It's a very simple question. He wants to know, and he just asked the expert's opinion. What is your opinion on the January report about whether or not Burgess and Welcher put the lock event on John O'Keefe's phone before the trigger event? Of course, the answer is we all know it didn't. The lock event was on John O'Keefe's phone was always after the trigger event. So we're talking about the two different systems. One was a Toyota on the trigger event. Okay, that's that 12:31:38 event, and then we're talking about the lock event on John O'Keefe's phone at 12:32:09. So that's simply the question. It's very simple. AJ has asked us simply about 3 times. Okay. It's extremely simple. So he did give him, I think he did. He said, I'm only now talking about the January report. What was your opinion about whether or not at either of those reports, the lock event occurred on John O'Keefe's phone before the trigger event? I mean, I don't know how many times AJ can ask it. He's asked it 3 times, and she gives it, we'll put it a different way. So he puts it in a way, and what was your opinion about it? And he should be allowed to ask what his opinion is. I mean, that's why he's there. All right. And notice how Brennan keeps objecting because he doesn't want the truth out. All right. This is trying to make it very clear for the jury with all the rigmarole we've seen the last couple of days. So go, AJ. Let's ask.
Ma'am, Your Honor.
Yes.
Thank you. Back to my question. Was there any circumstance based on your review that if the text stream event occurred at 12:31:38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
I wish he repeated.
Did you create a PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint, and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is.
Following your presentation of the PowerPoint to us, at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough, fair enough. Did that report, or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
Sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the differences.
In the first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
He's now asked open-ended questions. Did you speak with, I guess he has said, what did you seek to do? I guess that's what she wants. What did you seek to do? Well, you know what I sought to do this. I mean, but this is kind of ridiculous because What Hank is doing and what she's doing is disrupting everything that the jury's trying to follow in terms of the differences between Burgess's report, his first and his second report. And this man on the stand, Matt DiSogra, who is from Delta, who's considered the leading company in the world dealing with data analysis, I can tell you that, is trying to explain how he analyzed. He was called in to analyze the difference of Burgess's reports and the effect that then it would have on what the opinions were, and then he's going to talk about how the opinions were not supported by the data, the real data in the phone. And what this is going on is not allowing him to do that, and it's just, quite frankly, it's outrageous. If Alan Jackson puts, did you try to do this? Objection. What were you trying to do? Objection. You have to give some focus to the jury, especially in this very highly technical area. That's extremely important, because we all know what Burgess did is widen the expanse so that the John O'Keefe's phone didn't have any activity on it after the text stream event. That's what they tried to do, because they knew they were in trouble, that he was still on his phone after they said the text stream or the triggering events, two words being used here, occurred. So you see Alexi is giving Alan Jackson pointer out of it. All right. But let's see if the judge allows.
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason? What was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I approach?
Yes.
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it.
Teresa tries to already makes a point. The first report, he didn't actually use the trigger time, he was beginning and end time.
What is that document?
Report, he
This is
numbers
a printout of
we
the
get that.
PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
May I have that back for me just a quick second?
208.
Thank you.
Hank didn't mind that because it also has Burgess's analysis in there. So he wants to say, look at this. So here's Burgess's
Your Honor,
analysis.
permission to display the PowerPoint presentation?
Okay.
Mr. DiSogra, can you still see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what is the how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With the court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide, what is this? What are we looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with in Mr. Welcher's presentation that you disagree with? It's up on the
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. He means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
No, I'm going to allow it.
The phone interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
I'm sorry, Mr. DiSogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the time, the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162.2 ends at 12:31:43. And they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event. So I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording, yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12:31:38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12:32:09 lock.
Okay, let's go to the next slide, please. What does this slide show us?
So this here, what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, we have a lot of numbers to go through here. And so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please. What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all the information comes from the Aperture reports collectively.
Okay.
From Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Find this
So this is
clear
the first
and
adjustment
informative.
we're going to talk about that was, and this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment. And we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3 second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Miss Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3 second delay? Or could that be different?
It could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3 second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3. And then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one, and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7. What are we looking at here?
This is an excerpt from Mr. Burgess's original report, his page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from. And that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned.
I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report?
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3-second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
In your opinion, was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask it to.
What, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
I am
Is there any
fascinated by
additional
him.
adjustment that you believe should be made?
The Aperture reports lay out two methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the three-point term.
And where did you get that information from?
From the Aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as point 154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the three-point turn event. So he uses that as an anchor point.
And that anchor point you said was the
On
end
air, as
of
you can
the
see.
text stream event, or the end of the recording of that text stream event.
Correct. The Aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those two times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that third column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So on this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but actually—
What do you mean sign conventions?
Sign conventions, he doesn't show when he calculates the difference, whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a +5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it, and he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20. And when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes +6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, without key switch, phone calls, and 0.154 on one table, and I calculated John's interaction window for all valid combinations from the aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the 3-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the 3-point turn data from the phone and the 3-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support 1 point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the 3-point turn?
He opines in that aligning the 3-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess in his report indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into 2 tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one
This
slide.
is how an expert should testify. He's
Let's move to the
given
next slide then.
credibility where it should be given and not where
Is
it
this
should
a
be.
continuation of
The
the?
second half. So think
He's a
of these
wonderful,
as a
honest
singular
expert.
table. I just had to split them up. If we
Okay.
head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my 2 tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you
But-
say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is
Same.
a continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay,
Just a continuation. Imagine in your mind is just rows 16 to 30.
okay,
And it's the same thing, same format, except for now we're just adding in that key on adjustment because again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
can we go to the next slide, 16, please? What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the tech stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the tech stream event?
Sustained.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the tech stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
What percentage is 3? Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
If I told you hypothetically,
I'm going to see you type out for a second.
What? She's asking to do what the percentages of based on even Aperture's data being fair and saying using their data, what are the percentages that the tech stream event occurred after, before, simultaneously with John O'Keefe's turn off of his phone? And she won't allow this in. This is ridiculous. This is ridiculous. I mean, it's just ridiculous. The jury's not sitting there with a calculator. And even if they were, so what? So what? I mean, this is probably the fairest witness. I have to tell you that I did receive during the middle of this from our independent with no dog in this fight, Stephen Plord, who was on last night and on last week. He said, just listening briefly to this testimony on defense is amazing. Amazing. Why is it amazing? Because they're taking the Aperture data. They're even giving credit to Mr. Burgess right now, not degrading him in any way, and saying, let's look at all this data. If you look at all this data, this is what all of it shows. There's a change, obviously, from their January report to make it in the May report, but he's putting it all out there. He said, look, this is what we see from both of the reports, okay? And I really dislike the objection when we have here, when you have a witness who's so clearly being so fair and talking about this is where they were. In the January report, Aperture had always had John O'Keefe's phone occurring, turning off after the text stream, okay? Always turn it off, every single time. Then they changed their methodology with Burgess to occur, hold on a second, let me see, to occur, to make it a different formulation. And yet didn't account for the formulation they did with that 3 seconds. And he's given the times that John O'Keefe's phone, even with their new calculations, would have turned off after the text stream event, simultaneously and before the end of the text stream event. And it's still a huge that Welcher didn't talk about, okay? And all they're doing is saying this is what their data should show. This is what they should testify to. If you're unbiased, like here, this is what you're putting out, okay? Turtle Boy, who, by the way, got a last-minute seat into the courtroom. Solak Girl is reporting that the jurors alert on the edge of their seats after Matthew DiSogra testifies that it's most likely that after John's phone was interacted with after Shannon's claim that he was hit by a car. All right, because it's clear and it's fair. It's fair testimony. All right, let's go back into court. Listen, you know, whatever it was, the judge decided against defense.
Following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay. Okay, we can take that slide down.
Actually, that's
is there a data recorder?
That's a better question
Toyota
than
SUV
the percentages,
we've been
was
talking
it?
about that 2021 Toyota SUV 570 that's designed to record impact.
Yes.
What is that? What is that mechanism?
That would be the airbag control module.
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed or the engine RPM or the accelerations of it.
Does the TechStream data event indicate that there's a, and I'm talking about very specifically the TechStream data, does that indicate whether or not there's a collision in the car?
No.
Does the TechStream data event mean that if you find a TechStream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw TechStream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many TechStream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
I object to the whole line.
And I need to see what's up.
Oh, give me a break. Give me a break. The whole point of this is to see how many times. Whole point of this is to see how many times the TechStream data records things that don't mean a collision. And the jury should be able to allow to hear the whole 8-month history and 7-month history and 6-month history and 5-month history, not just 10 days or 1 day or 2 days, because that shows you that TechStream data and a triggering event does not mean a collision, which is what Aperture is using it to say. I mean, it is simply outrageous that there's an objection from Brennan. Now, the question is, are these objections really going to matter to the jury? I think the jury wants to hear what Mr. DiSogra is saying. I know I could listen to him all day. And this is on data. I mean, he has made data interesting. Excuse me. He's even made data sexy, right? You'll say, well, data is boring. This data is simply not boring because it's so fascinating and it's so clear. All right. When we talk about history, it's just like with a doctor, it takes your history when you go in. Your history of what happens is so important. Did you have chest pains anytime during the 8 months? Not just during the last 3 days, right? Did you have pain in your back in the last 8 months? Not just during the last 3 days. Did you throw up during the last 8 months? Not just during the last 3 days. I mean, history is extremely important, and we're only talking about 8 months. We're talking about this, and we're talking about her car. All right. Remember, even using the data that Aperture got, they got it from not necessarily her car, but they also took the exemplar cars when it came to the issue of the infotainment system turning on, that there was a 3-second delay. And you don't know whether, since we all know that things are different, we only know about that one car. If this were an actual study submitted for science, for instance, on drugs, it would never survive with just one exemplar. Never in a million years. Never in a million years. Absolutely. So let's see what we have in question. Column 6 sitter. Am I misremember much of this is what Alessi wanted Welcher to answer, but was denied or not answered? You're absolutely right. Alessi tried to go there on some of this data and it was objected to. Okay. It was objected to on the cross-examination. So maybe that's a good thing. Maybe that's a really good thing, because when you have your own expert and it broke that they could put Mr. DiSogra in before the weekend, I think this is fabulous for the defense. Now, is there still a possibility? There was a 10% possibility, even using Aperture's data, which could be suspect, right? That John O'Keefe's phone ended before the text stream data. That was only a 10% possibility out of 25. I mean, that's reasonable doubt right there. That itself, ladies and gentlemen, and everybody else who was watching, including Tubi the Poodle, that's reasonable doubt. Thank you, Colin Sixsitter, for that question. Louise P., why doesn't AJ say, so this means John's phone was used by him after the event? Because the court won't allow it, because that's a conclusion that AJ can't ask in a question. He can argue that afterwards, because that's an argument. And Judge Bev Cannoni is not going to allow anything that helps the defense, all right? But maybe he can get the witness to say that out of the text stream events, the conclusion is the positive means what? The positive means that the phone was being interacted with by John O'Keefe afterwards. And let's see, I'm sure there'd be an objection to that too, because what's coming clear is that the prosecution doesn't want the truth out there. If you are seeking justice, let it all hang out. Let it all come in, okay? I mean, we started this morning with the motions. They call it something else, but it's really what you're familiar with, the motion for a directed verdict, that there's not enough evidence for a jury to find under any circumstance that a conviction could be obtained. Those are normally denied. I expect it to be denied in the normal course of things, and I truly expected to be denied in this case, because there was no way Judge Cannoni was going to dismiss any portion, including the first portion, which was that even though it didn't require intent, that because she was drinking, she had to know knowingly that somebody could die as a result of her actions. All right. Oh, come on. All right. It's the same standard basically New Jersey has, that if you do something purposely or knowingly, or that you purposely or knowingly an event could happen, that substitutes for intent on a large event. I see there's a lot of discussion, by the way, going on about my hoodie, which I did have here, because in case you all have action, it's a fabulous hoodie. There's other colorations. There's I forget which one I also really liked. I bought the white one in this too. There's a black. There's a isn't there a desert compilation, Dizzy, right? That I think I'm going to buy them all. This hoodie is great. It fits me, especially if I want to wear, it's unisex, a sweater under it. But if I want to just wear it kind of like tight as a shirt, I think camo, that's it, camo. There's a camo hoodie, which I have to get. I think that I would get a smaller size. I think that mine is small, but it says I'm just looking at it. It says, do not bleach, cold cycle machine wash. Oh, thank God it's machine washable. Okay, I'm going to get the camo in the extra small if you want to wear just basically a tighter. There they are. They're the colorations. And I know this is going to do more now, because these are so great. and the fabric is so great. I don't know how I got talking about this, but I saw that all of you were talking about my hoodie. I also have, and I haven't been able to wear it. I was going to wear it. Let's see if I have it here. Hold on a second. I have to look. I had my little cap, and I don't see what I did with it here. I have to find it. My cotton beanie, which I wear when I do yoga. But I was going to wear it with "Where in the World is Justice?" Michael Bryant, which I apparently screwed up. I
understand. Respectfully, it won't be very much longer.
Let's go
You
back.
reviewed the tech stream data, otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
And last question, do any of the tech stream events or do any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
Neither of the events on that date were triggered by a collision on the tech stream data. Boy, was this a clear, concise presentation. I assume if he's finished before cross, it's going to be a morning break.
Jurors, we're going to take the morning recess.
Called it. Okay. Actually, I'm going to, as I'm
Can I
with
see
you right-
counsel at sidebar to save us some time, please?
Okay, as I have you here, I'm actually going to ask Stephen Plord if he can come on our show tonight. Come on our show, just so you know what I'm doing. Our show tonight at 6. Tonight at 6. I have to tell him for no longer than a half hour. Because we don't want to misuse his time. Let me see if I can dictate this. I'm better for no longer than a half hour. Okay, so just so you know what I'm doing, because I want to get his take on it. But if I could type, if you could see my typing, you guys you'd understand why they call it Linda speak, because I can't seem to whoops. Now it's dictating. Hold on a second, everybody. Can you come on a show at 6 for no longer than a half an hour? Okay, I just sent that to Stephen Plord. I'll have an answer for you all hopefully in a second. And I may have to, by the way, just leave for a bit because I'm expecting somebody here that I may have to see for a few minutes. But let's talk about what we just heard. I think this was such a fair presentation. It didn't show that he was changing his testimony, skewering his testimony. He gave you, he gave you the data that Burgess did. He told you that Burgess didn't account for the 3-second offset in the at any time after he found the 3-second offset in the car going on, and that really you don't know if it's a real 3-second offset because they only used one vehicle. But none of the tech stream data in the 19 events that Karen Reed had was ever triggered by a collision. So, and that's what they're using, Aperture is using to say there was a collision. And then even if you take all of the data, and he did all the data that Burgess did and that Welcher then used, okay, which I thought it was interesting because, we all think that, we're not really thrilled with the history of Shannon with an N. Burgess, but he gave him credibility in the sense of here's all his data, just using their data, not anything we did, using their data, okay? What we found is that that 25 of the 30 interactions, even accounting for the clock changes and the clock differential, that John O'Keefe would have had to have that phone interacting, reading his messages, and doing that lock at least 25 of the 30 times. 2 of the 30 it was simultaneously, and 3 of the 30 it was after, using their own data. Now, when Welcher testifies, he only uses the data that gives them the after, okay? He doesn't tell you about all the data that gives you the before, because Burgess didn't do all the calculations all the way through. He put the data there, but he didn't calculate all the way through. So what DiSogra did is using Burgess data. It really shows how they're phoning their data, because he calculates all the way through and says, this is what it shows if you calculate all the way through. So if you're going to misrepresent, in my words, if you're going to misrepresent, I think that's what the defense is getting to, that the data, and just take 10% of it that's on your favor and say to the jury, therefore, John's phone was used, was used before the text stream event. That's really a misrepresentation. Now, Alan Jackson didn't say that because DiSogra is so honest and all, but he's going to be arguing that later on. You can bet your bottom dollar on that. And that I'm not a betting woman. I play poker, but I'm not a betting woman. But I would bet on this, okay? That's going to be the argument here, that they're phoning everything to try to get Karen Reed. And you heard, interestingly enough, when they did the sidebar, okay, and there was objections, and during the before that sidebar, when we did the motions for the directed verdict, or whatever Massachusetts calls them, all right, you heard Alan Jackson say this was a vindictive prosecution. And apparently that's all on the record as to why it's a vindictive prosecution. So I know that we are going to go now. We're going to have to listen after the jury takes their mid-morning break. I mean, quite frankly, I wish DiSogra could have stayed on the stand all day. Quite frankly, I'd watch him all next week. I mean, he was just so honest. Now, interestingly enough, he hasn't testified that much. He has been declared. He basically is the backup person that gets all this and analyzes it for Delta. I mean, he's the one that does this work, but he hasn't testified all that much. He was declared once as an expert in New York. That shouldn't matter. We know that Burgess only had 4 cases on his federal testimony list, and we heard about one of the cases that wasn't on his list in this situation. And we also heard that in the case that they talked about, the Glover case, he never got to testify. He was pulled from the case, he says, which sounds like he was pulled before it settled, and then afterwards, the defense, who had hired Aperture or his company or whatever it was at that time, decided to settle the case. Okay, maybe they found out about that. Okay, yeah. So let's look at some of your questions coming through. I see that they're going down fast and furious here. Yeah, Brennan, I don't know what Brennan's going to do here. I mean, he tried to get the truth out with regard to the statistics, and I guess he won that objection. I don't know why he won that objection, because what does it highlight? The jury's going to go in there and going to say, let's see, there's a 10% chance, even using their data, which is suspect because it didn't account for the 3-point offset, right, of time, that the John O'Keefe's phone was last used before the that text stream event, which Aperture is considering to be the collision, which apparently it's not. Two of the 30 times it was simultaneously, and 25 of the 30 times it was after. So F sum SW93, what's the bigger cover-up? Question mark. John was killed because he knew too much, and it goes high up. I pray the FBI is still involved. Yeah, there's a lot of different possibilities here. But the issue is, did Karen Reed kill him? I mean, I don't see the prosecution proving their case. And if you think that Blue Man Tube Group grease paint in blue, which, imagine if you walked through the buffer zone before all of us won. And Michael Bryant was a plaintiff in that buffer zone, my partner, who I enormously respect, because we did that at the beginning of this case. When you all didn't really know us, and when we took it on ourselves with Michael Bryant to become a plaintiff in that First Amendment case, and that's Jason Grant is the lead plaintiff, but the court ruled that applied to all the issues with regard to reporters, and that's us. Michael Bryant was there as a reporter. All right, that's us, and journalists gathering information. They can be in the buffer zone at any time. So there's a lot going on this case that you all know has been wrong. But I assume if you walk through the buffer zone and you were wearing pink, and there was 30 people walking through wearing pink, the cops would arrest them and saying, well, pink is a Karen Reed color, right? So kind of interesting that the blue grease paint was chosen by the defense experts. Now, maybe it means nothing. I just pointed out because of the way the Massachusetts State Police had been enforcing buffer zone. I don't know what's happening outside in that buffer zone today, whether people were able to get it all together to come. It's been raining a lot, as you know. By the way, that sounds like Tubi the poodle alerting mom that somebody is here, which then I may have to leave you for just a few minutes, but not yet. Let's talk more about this, okay? Let's see. He's going to scream. Oh my God, that's kind of funny. Allegedly, maybe he's going to scream and ask about Signal. Yeah, Signal is one of the biggest apps in the world. It's like WhatsApp is encrypted. We talk WhatsApp all the time. It's encrypted, and use Signal a lot when you're lawyers. It's encrypted. Why? Because you don't want the press and the media to intercept. That's, I'm sure, one of the reasons the judge didn't give Karen Reed earphones so she could hear what's going on in the sidebar instead of having her traipse up with the whole defense team to have her constitutional right, because she has a constitutional right to be at those sidebars. Important decisions are made at those sidebars, maybe more important than any other place in a trial. They're made at the sidebar, especially in this case where we seem to have sidebars a minute, right? Objection sidebar, and all. I'm also actually surprised she let the directed verdict motions go in open court, because usually she does not. Last time they were apparently not made in open court. I think that's a violation, and I think that any news media that would object to that would say it's a violation. Now, that during lunch hour, I am going to go on a mini rant about the discriminatory nature of this case, and it's not going to just be about what we saw with people, a person like that, and having these men come in to try to undo what the state police called the whack job medical examiner. Okay, it's also going to talk about the randomizer system, and who has gotten in, and Jessica Machado. By the way, I'd like you to all go before we do this our rant and look at her ex Twitter post, because she's been trying to cover this case for you, and she can't seem to win that randomizer very often. And quite frankly, it's outrageous. Sometimes they have seats that are empty there. The people that should be covering this case don't cover it. They didn't make arrangements for an overflow room, which is done in almost every high-profile case, so that the cameras then showing the reporters in the overflow room everything that you see. And it's important to see the jury. We want to see the jury. All right, we want to be told about the jury. Sue from Boston, she gave us the jurors' reactions yesterday. It was wonderful, as opposed to some other reporters that seem to have a bent and are there just to be arms, it appears to me, of the prosecution. And that's only my opinion. But we're going to talk about the whole nature of women being pushed out of this case, or being denigrated or demeaned here by some of the decisions both made by the Commonwealth and maybe unintentionally made by the court system with regard to their randomizer. Now I know we're in an area that DEI is not acceptable, But quite frankly, I would like to hear, when I go out shopping, I want to go out talking about things with my girlfriends. I don't want to go out talking about things with my non-girlfriends. I don't even want to take my husband out shopping because I want to get my girlfriend's perspective. I want to get a woman's perspective on what I'm buying, okay, or what I'm talking about. I want a woman's perspective. That's what I'd like to see more in the courtroom. I'd like to have a woman's perspective about what the jury's doing. The half of the jury are women, and there's a reason. There's a reason why the juries picked the way they are. In case you don't know, when we have we do focus groups on trials or mock trials, we come up with science based on sociological studies, the ideal juror we want. And sometimes we say the ideal juror is female. Now, can you knock somebody off a jury because of their gender? No, that would be in violation of the court rules. But boy, you're certainly looking for that juror, and you don't want to knock them off if they come up. And I would like to see, it may very well may be split here. I'd like to see the different perspectives, both female and male, that the jurors have. And one way to kind of get that is to see how people in the courtroom who see the jury and see the responses and get the feel, and all, and tell you who's writing and when they're writing. I'd like to see that. And I'd like to see somebody, and if you're going to randomize, then randomize with everybody gets a chance. Don't just put everyone, here, this week you get this. This week there's 6 reporters. Next week there's 5 reporters here. Next week there's this. And then if you don't come in because the only reason why you're being put yourself in the randomizer is just in case there's a closing statements, you lose your spot. You either come in or you don't get a spot at all. Period. At all. This is your spot, and if you don't do it, you don't get the next spot. If indeed they have to go over and over again, Now shit happens. We all know that people get sick and all. I see somebody. Do you mind, or if I leave you for a few minutes and Diz will play something for you and I will be back to you? All right. I hope you don't mind. Just give me a few minutes. Thank you very much. Okay. You hear Tubi barking. I have to just go deal with this for a moment. All right. Talk among yourselves. Get your questions ready. I see there's 1-star questions. Isn't this necklace smoky quartz is very nice. I think it's fake smoky quartz. It was actually bought by my assistant at a garage sale. She put all these beautiful necklaces in a garage sale, and I just think it's beautiful. But I think it's faux smoky quartz. So yeah, thanks very much. But I'm going to leave you just for a few minutes. Okay, bear with me.
As the Commonwealth rests, now it's our stage. We start to turn the final page. With truth and facts, our case begins. Defending rights so justice wins. Let the evidence speak, let the facts unveil. In this trial of truth, we shall not fail. United we stand, with courage unfeigned, till justice is served and integrity gained. David, Ellen, Liza, Bob, and Victoria proclaim free care and read the core of our aim. With voices united in harmony we stand, seeking justice across this troubled land. Let the evidence speak, let the facts unveil. In this trial of truth, we shall not fail. United we stand, with courage unfeigned, till justice is served and integrity gained. With truth on our side, no need to hide. In the courtroom where justice will abide. Facts laid bare with clarity and might. We march forward guided by the light. By light. Whispers of deceit in corridors so grand, unmasked lies spun by hidden hands. An MSP and Canton PD's tale of woe, shadows of corruption that we must show. Norfolk County Superior Court, where truth's often bed, we shall shine light on the injustices they've lent. In our defense of care and read, scales must realign. For justice denied is a grievous crime. Let the evidence speak, let the facts unveil. In this trial of truth, we shall not fail. United we stand, with courage unfeigned, till justice is served and integrity gained. Till justice is served and integrity gained. In the silent hall, Linda unlocks the mystery's thrall. Michael charts truth with steady hand. Through shadows deep they make their stand. Dig through the lies the world conceals. Evidence whispers what the dark reveals. Mascots to be and domino play their role, guiding us closer to justice whole. Justice serve the truth untamed. Every story we've unframed, chasing facts as they unwind. Through the chaos, clarity shines. Blackened files and forgotten tales echo down corridors no wind wails. Together they conquer every climb, steering through the storms of crime. Every lead, another thread to pull, through blurred lines where the danger's full. Linda sharp as a blade of law, Michael's insights flawless and raw. Justice serve the truth untamed. Every story we've unframed, chasing facts as they unwind. Through the chaos, clarity shines. In the shadows, truth takes form. Every clue a raging storm. A puzzle piece is left to find. Justice served, no wasted time. Follow the trail, step by step. No secrets kept, no stone unwept. Facts lay bare, the proof aligns. Beyond the doubt, justice shines. echo in the night, a legal war, a righteous fight. Advocates with steel resolve, the tangled threads they will dissolve. Through the chaos voices plead, the gavel strikes to meet the need. Strengthened hands to bear the weight, each decision carves our fate. Follow the trail step by step, no secrets kept, no stone unwept. Facts laid bare, the proof aligns. Beyond the doubt, justice shines. Linda's keen, a mind so vast, breaking down the shadows cast. Michael's sharp, a guiding hand, on firm ground the fearless stand. Secrets kept, no stone unwept. Facts laid bare, the proof aligns. Beyond the doubt, justice shines.
It ain't good. Let's see. No, don't be messy. Don't split hairs. This is about Shady's magic hair. This hair survived in a Lexus, survived in a blizzard, and still survived miles. I don't know what you're about to see. So super strong, it's like magic. Yeah, we're talking about Shady's magic hair.
All right. I don't know. I want to listen to that. I don't know about you all. That is Cat Speeds. And there we go. SkyStar's page. Thanks for that donation towards, we'll try to use it towards cat vibing with Cat Speeds. Aren't they great? They're just fabulous. I mean, quite frankly, I was like, oh, this is kind of relaxing, especially since I think we're all going to need to relax a little bit because we're about to hear Hank Brennan. Okay, and this is going to be interesting and exciting. And I think Matthew DiSogra is going to keep his cool. As we said today, our thumbnail was Defense Matters, M-A-T-T, and then with the E-R-S, Defense Matters. That's our thing today. And I don't remember the testimony being this good. Okay, am I able to say, I have not talked to my husband about this case. The only time he appeared on with us was to tell us generically what medical examiners need to do when the police are in there, come into an autopsy. We have a little bit of an episode, and it's been cut, that when they come in, you're trying as a medical examiner to get information from the police. They're trying to get information from you. But the most important thing is, if you're a medical examiner, you get information from the police, you maintain your independence. Okay, you listen to what they have to say, but that does not mean that you are going to specifically adopt what they say. As a matter of fact, Dr. Scorti-Bello, the reason why she took such disdain from the state police right early on. I mean, right early on, remember, they called her a whack job. And then and Proctor said, well, you should have let me go to the meeting. And then some, and stuff like that. What was he thinking? He was going to threaten her? He was going to threaten her? And let me tell you, there are, and I've said this before, there are cases, and you can Google them, where the police have been so sure about their opinion that they've gotten medical examiners fired, right? They've gotten medical examiners fired here because medical examiners need to work with the police all the time, whether they like it or not. So that's a very serious issue. And she held her own. And so then Hank Brennan, he knows he has to call her. I don't think he was planning to initially, but he figured he had to call her. So he had to call her. And then after her testimony, he went after her on direct. And then you heard Welcher demean her. And we're going to talk about this again. We did yesterday, and demean her on the basis of it was clear he was saying she didn't do what she had to do, to make the determination. She has seen impact injuries. And remember, on the Commonwealth's case, they had a Trooper Paul backing into John O'Keefe at 24 miles an hour, and him doing a pirouette and coming back down on his head. I mean, so they keep changing what they want. And now they have, well, this was a clip. It was a clip. Well, I don't know how they clipped him if he got out of the car. What did he do? Just stand in the street for the whole time? Come on, give me a break. All right. And then you heard our own expert, Stephen Plord, who, let me see if he has responded. Not yet. We'll see. It's only in California. It's only 8:48, obviously, who said that if the accident happened the way the Commonwealth said it happened this time, with a clip of the knee, John O'Keefe would have been, his rotational forces, he would not have landed where he had landed there. It's simple put as that. And of course, he talked about how the scene was something that was really handled improperly. That scene had to be locked down, guarded until the snow. You just wait for the snow to melt. You don't do anything. No one gets access to it. No one gets in. It gets to come by, and 11 days later, oh, I found a piece. No one gets to do any of that. All right. And quite frankly, it's kind of interesting that, with all those snow blowers, which may help Karen Reed here, those snow blowers, because, nothing is seen, by the way, beforehand, before the car goes into the Sallyport, right? And then you have just a few pieces. Then all of a sudden, it's like a deluge of plopping pieces down, and the Commonwealth, to me, is trying to hide their case here. They're trying to hide Barrows, the Dighton cop, who said Karen Reed's taillight was just cracked a little bit, which would indicate that it probably did hit the car of John O'Keefe. And remember, that may not have been considered an impact because it was so light, but it just may have hit it at the right point with that fin coming out of his car. All right, but really, okay. Oh, somebody just put up something with a word. I want to tell you a secret. Sam put up "blessed me" equals Twizzlers and caffeine. Of course, I love Twizzlers. It's a little secret. I love Twizzlers. Okay, I used to love nibs. They used to make licorice nibs too. Just so you know, I can't control myself if I go to the theater. I have to get Dots if they had them. I only find them in theaters and Twizzlers. All right, and yeah, Blessed in Texas. We're gonna have a Twizzler discussion, Sam Poop. I love Twizzlers, but can't eat sugar and lose weight. Well, that's a problem. Although I'm not sure anything in Twizzlers is real. I don't know what we're eating. Maybe we're eating plastic. I have no idea. Yeah, okay. Red Vines Dots Girly, says Skystar's page. All right. We all have our, I wouldn't say vices, but we all have the things that we kind of like and all. Somebody has a headache. Oh, if you have a headache, please feel better. Feel better, please. Feel better. Feel better. Feel better. Well, if you don't have a headache now, you may get a headache in when we're listening to the cross-examination. I wonder who the defense then has after DiSogra, or did they assume that DiSogra is going to take the whole day here? Probably they're going to assume he's going to take the whole day. But as I told you, I would have led off with a witness that was really good leading into the weekend. I think this is a great witness leading into the weekend. Normally you'd say, oh, the person with the tech data. Oh my God, listen to more tech data. No, we were glued to our seats, weren't we? I don't want to get sexist here, but he does present himself nicely in front of the cameras and the jury. All right, I'll just leave it at that. And he also presents himself honestly, and he also presents himself morally, and he also presents himself truthfully. And to me, that's the whole package we've got there. And to think that went right at the defense went right at Burgess and Welcher, but they did it in such a respectful manner, didn't they? None of this, people like that, persons like that. Okay. And and AJ is getting basically all his questions around, except he wouldn't let him do the math, which was most ridiculous. 3 out of 30 is 10%. Objection. What the? Being good. I'm being good. Okay. Yeah. So you have Mike Cameron has that. Yes, we have that case. He was blocked in Commonwealth of Massachusetts, Suffolk Superior Court, KV versus KV. Yes, why? Because he's found that his methodology was bad because he was using 50-year-old testing on corpses, which doesn't imitate real world. And he even used it here. He used that study, which did I keep it here because it was so ridiculous. The study, let's see if I have it here. I should talk to you also about there's a new motions being filed. Okay. I don't think I have it right with me right now. Let me see if I have it over here. I have separate piles for separate days, as you could imagine. All right. No, I don't have it right here, the corpse thing, because it was so ridiculous. I think I threw it out. No one's going to allow, first of all, a corpse, dropping a corpse head on a skull on the ground. That's pretty disgusting. It would never be allowed in the United States. It would never be allowed unless you had permission and all. There was also a case, Salem versus Shannon Shee, which is costs. So we talked about this last night on the show, which the court denied his costs for charging or his staff charging for reading medical records, right? Because, and quite frankly, I think the accident reconstructionist has to read them, but I think what the court felt here is that it was excessive and it was overbilling. And so they struck $16,000 from his bill for seeking costs. He was seeking costs only, okay, of $228,000 just for costs, okay? Oh my gosh. So like, oh, thank you. I love this channel. Other YouTubers say they're attorneys. I'm sure they are. With Linda, you can actually see the depth of her work. She's not just knowledgeable, she's established and a true professional. Thank you very much. I've tried a lot of cases and I've handled a lot of cases, and I still am an active with a full practice trial lawyer and run trial teams and all. When I get cases right now, though, a lot of them seem to settle. I do high profile civil work right now, but some of my civil cases are just so large. They take, percentage of your time. Luckily, I have great co-counsel, and I also am of counsel to a great firm in New Jersey that they pick up the slack when I'm here with you. But I do end up answering. Like the other day when we got off, I was answering like 15 emails on things that had to be done in anticipation of a federal court conference and all. So, I'm an active practicing lawyer. With active clients, and then I see active clients. Last night I took my husband with us because it's partially social too, but I had to see a client, and tonight I actually have to go. You remember when Donnie Moss was on with Jane Velez Mitchell? We did a fundraiser for the animals and the fires. Well, Don Moss runs a nonprofit that's all his. It's called Their Turn, and it's about animals. So I will be seeing him tonight. All right. And it's nice to give back to people that have given to this channel. And I hope to give back there. That's why I'm going to be jumping off at 7 o'clock, even if Michael Bryant goes a little longer. By the way, tonight's show will be half on Karen Reed. Hopefully Stephen will come on to talk about this, because he, as I said, he texted me, which would have been like 6 o'clock in the morning or 6:30 in the morning, whatever. He texted me that this was amazing testimony from this witness, Stephen Plord. And then the other half of the show, we're going to be pleased to have Lauren Conlon on. She's going to give us a full Diddy update and what to expect in next week's Diddy. I don't know if you're watching any of the Diddy case. Well, let me put it this way. If you went to Catholic school, all right, Catholic nuns would never have you watch this case. I'm just joking, but I've been joking in jest. The stuff that we're hearing is unbelievable. It is believable. And what's amazing to me is whether or not this gets into RICO or not. But I think this week they had some acts, if the jury believes they're true, does get the case into RICO. I worry about the prosecutors using RICO and not the way it's intended, as we saw in YSL. It was never intended for that. All right, I guess we're going to have to put up a poll red vines or Twizzlers. Can we do that, Diz, at some point when you get a chance? And, because we seem to have a red vines versus Twizzler, thing going on here. Well, thank you so much. So this won't be a criminal poll, but maybe it is. Is it? No, I guess red vines or Twizzlers. What you going to vote for? Okay. All right. I don't want to sway you. I don't want to sway you all because we really have this really going on. Yes, I had 7,000 trial. Phil Spector versus Alan Jackson. I spent basically 6 months in a courtroom. Alan Jackson back and forth. And 3 weeks of that, I was out with mycoplasma pneumonia, which caused me to have reactive arthritis, which prevented me from doing the next trial because I had to deal with that because mycoplasma pneumonia was really serious. It actually was invented. It was actually used as biochemical warfare, believe it or not. And I had a very serious case of it and went back 1 week earlier than the doctor recommended, but I felt I had to get back into that courtroom. So I did, but we fought every day. And maybe that's why Alan Jackson said, "I love you, Linda." It's at the beginning of our thing, because we fought every day. And we try to get our evidence included, excluded and all, but I think we did it pretty much for the most part, pretty fairly. Although Alan and I began on a really bad note initially, but that kind of got better afterwards. So no problem. And I think he was shocked when I got the hung on the case, but he kind of also expected that if anyone could get it, it was me. Now, we try to be respectful on this channel here, as you know, okay? We try to be very respectful on this channel. Oh my God, do we have something else? Nerd gummies clusters? They're not liquor. They're not phony licorice, though, are they? So I think we just got to go with red vines and Twizzlers. All right, let me give you some of the comments about me because I know you're here and I love me. Somebody named @SouthernGal1345 commented, "Haven't seen LKB in a while. Is she ill? She looks bad." I actually responded, I said, "Not ill. Most people think I'm looking pretty good." I mean, I don't know. I mean, that must be somebody who doesn't like my opinion on the case. I always find that. And then A Koala, KWALLA 123 KW commented, "She never shuts up." Well, I'm here to talk to you. That is the point. All right. I'm here to speak to you. So we actually wrote back and said, it's Linda and Michael Bryant's channel. That's the reason they speak. All right. Of course, if we would invite @Koala 123 KW, come on the show. You want to talk? Let's see what you have to say. I'm not afraid. Even Southern Gal, come on. Write us at justiceservetv.com. We'll put you on the show. We'll hear what you have to say, and we will be respectful to you, even if you don't look so good, because obviously you're interested in looks, or even if you're not healthy, or if you're healthy, or whatever you want to say, come on the show and say it, but don't do it in this manner. All right. And that's why we ask all of you to be respectful here on the channel. And there's certain words I don't like. All right. Although I see other people that we've had on the show use these words, and because of the First Amendment, I will defend the right to say them to the ends of the earth. But here, when we're running the show, we just ask you to be respectful. And we tell you things that you may not like. We've said that the danger in this case, in our opinion, that the jury, and you saw a little bit of that with regard to Hank Brennan's argument, could get convicted on count 2 on the basis, well, she was drunk, she must have done something. She must have hit him. And somehow, even though things don't align right, we're going to go there. And that's where the first jury got apparently hung up on. Now, I have in my hand the update. I have 2 things in my hand. The updated defense witness list, which, by the way, has, and they're not going to call everybody here, but they have to put everybody just in case, 91 witnesses, of which they had Matthew DiSogra, MSP, Charlotte, North Carolina, as number 88. He's one of the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 expert witnesses they list. They're not going to call everybody on this list, but we're going to cross them off as they go. But this morning there were 2, Hank Brennan, just filed 2 motions out. Commonwealth's motion to preclude inadmissible hearsay. Now, what it was is the defense filed 4 new witnesses. Those are the witnesses on the Proctor chain. You know, normally courts don't allow the text to come in unless you have all the witnesses on the text testifying that that's the text they set. So they filed that motion, just expecting that kind of issue and maybe deciding whether or not they're going to call Proctor. Well, apparently, between the defense, what Brennan says, the defense intends to offer the communication of 9 individuals, only 3 of whom had partial contact names saved within Michael Proctor's personal cell phone. He then says that this information is federally, there you go, federally protected and confidential. Federally protected and confidential. Of note, the confidential record indicates there are a total of, listen to this, 38,707 text messages exchanged within this group beginning on October 18, 2021, ending August 31st, 2022. I don't know if I've ever had 38,000 text messages exchanged with any group. Hank notes in his footnote, while portions of the federally protected text messages were revealed during Michael Proctor's testimony during the first trial, the records remain subject to protective orders of the Norfolk Superior Court and the United States District Court for the District of Massachusetts. Okay, so he further notes that's defendant's burden to satisfy the requirement of authenticating these communications, okay? That the communication was altered by the witness on the stand. But this will require the judge to determine the relevance of each. And furthermore, he objects on the basis that they contain hearsay upon hearsay, and each statement of the text must conform to the exception of the hearsay rule. He also states, this is very interesting, Michael Proctor is available to testify and could authenticate and perhaps adopt and acknowledge the statements sought to be introduced. So we have a little game going on right here. The defense wants Proctor to be called by, the prosecution wants Proctor to be called by the defense. And then they want to go to him, and Investigator Proctor, I know you apologize for this and you've lost your opinion, but as a state trooper, you've seen a lot of crime scenes. Do you still believe that this was a homicide? Yes, I do. That's what he wants, okay? That's what Hank Brennan wants, okay? So what he's saying is the out-of-court statements to the police investigator attributed to Michael Proctor in his capacity of the case officer assigned, not lead investigator, which is what Noble said he is, are permitted only through the testimony of the police officer and limited to the facts that establish such knowledge, and is allowed when the police action or state of police knowledge is relevant to the issue in case. So Hank Brennan wants to prevent from having the whole truth out. That's how I read this, okay? By using this kind of bullshit. In the first trial, they had no problem introducing all these messages. By the way, I see the court's coming back. There's also a motion for reciprocal discovery with regard to Kelly.
Not a problem, Your Honor.
There's a witness in this case. Okay, let us go into court. Let's listen to Mr. Brennan. I'll be behind the
Good
TV
morning,
after
sir.
I'm here.
Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022?
Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022, or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, were you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right, right. So there's other things that will trigger text stream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexis calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data in the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the case.
You're saying it would meet that?
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture reports reference.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No,
You have no idea, right?
I don't.
And neither do you, Commonwealth.
Okay.
There's no proof. That's the point. Sorry to
I want
interrupt.
to just ask you some questions
And if
about
there's
your
no data and
background
you don't know,
and then leading
you
into
can't
this
prove
case if I
beyond a
could.
reasonable doubt.
You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month, correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction, it was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus, as part of your specialty, on EDRs, don't you?
That's correct.
Event data recorders?
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it, but oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Oh, yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
This would be fine if he was giving an opinion on that.
In
He would
this
have
case, you had
taken
an
the
opportunity
data
to
that
review a
Welcher
number
and-
of
and
reports from Dr. Judge
Shannon
Welcher
Burgess used
Yes.
and
Yes.
analyzed.
and Mr. Shannon Burgess.
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this case?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case,
You what?
Mr. Jackson,
Right, okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher.
Jackson's
correct.
gonna come
Reports
back
that you're
and say,
critiquing,
did,
right?
Mr. Brennan
Correct.
ever
Did
ask
you
to speak
see
to you?
Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about. You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
But they had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So it's sustained.
And then there was Memorial Day weekend.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's
Yeah.
no reason for you to hold on to it for a couple extra days.
No, I think it was the 25th.
You know what was provided to the Commonwealth, that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked you?
My clients, Mr. Jackson.
He said, please have this on the 25th.
We had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
You mean the Sunday of Memorial Day weekend? Okay. This is going nowhere. This is ridiculous. What is he going to try to get his
When you
testimony?
first got
stricken
involved in
from
this
the court and
case,
get the
it
hand?
was last fall,
Brennan?
Correct.
and at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
And there was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules and try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So, can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. Now, whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download research of Ms. Reed's Lexus materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
Judge,
In that form, it's sustained.
it's strict.
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits, and Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip lock, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mr. Burgess' proposed protocol labeled reattempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see if it actually, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on and ignition off information
Yes.
in an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. It's pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry, so can you restate it, the whole question?
I'll
Yeah.
ask it again.
Yeah.
You said you have some experience in accident reconstructions.
Yes.
Don't you want all the data available? More data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, as a data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions. In some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time that you can match with the text stream data, correct?
Yes, it does.
Because you know text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead, like
That's
a stopwatch.
Correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there, if someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustained. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips, and it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas, and then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight? Objection.
Sustained, you can ask it differently.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there, there could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess?
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing?
He did.
He explained to you what he was doing?
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
I understand your point.
Yeah.
If you see, as an analyst, a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. DiSogra's new PowerPoint, 52525. You've made a modification to your PowerPoint?
Yes.
You've made an amendment to your PowerPoint?
Yes.
So there is something that happened, you received new information or new data, and you updated or change your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible, so I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
Objection.
I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say, generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Okay. We can turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did not.
reports. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
Well, it's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the three-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Turn to the next page, please. You point out 2 times for the jury, the Lexus event 1162-2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
That time is based on 2 things, the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 123209 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 123209.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are 2 different devices, 2 different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so, in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, the way I'm not the only instructor, collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger time.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're
apertures.
not suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No.
So you're not offering criticism on that, so just so I understand.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were
A little
suggesting
different.
those questions about, well, since you're looking at the end instead of the middle, then you're going to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds to the time of the trigger because you're starting at the end from both devices.
Objection, Your Honor.
I'm going to allow it if you can answer it in that form.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, they were basing it off the end of the event. The end, not the trigger, the end. Comparing it comparatively to the end of a different device. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
You see 12:32:09 minus 12:31:43, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly, before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report? Isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in that form.
Did you see, when you reviewed reports, that Dr. Welcher uses this exact number, plus 26 seconds in his report?
I got the number from the PowerPoint.
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough, fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with. Sliding that a little forward. So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data?
Objection.
I want to see you at sidebar.
Okay, I think this is going nowhere because the witnesses made it very clear that he was there to analyze the data that was presented to the jury by Burgess and Welcher and show what it means, okay? Because if you were looking at their testimony, they took, in my opinion, the portion of the data that would support their version of events that the prosecutor wanted and not all the rest of the data. Now, what do we have here? We have Hank Brennan trying to suggest that somehow, and I had to stop writing, that this witness is not qualified to do data analysis because he doesn't have an ARCA accident reconstruction. ACTAR, accident reconstruction. Well, let me put it this way. That's not like being board certified like a forensic pathologist, okay? It's ridiculous. And then he's trying to buttress Burgess's testimony that he took an SD card. And what this witness said is that he was surprised by that because they had agreed to an established protocol. And the reason why you send your expert with the other side's expert, normally there's a protocol that's established that's either going to be followed or that you're going to watch. And then when they got there, Burgess did something, removing the SIM card. By the way, they couldn't put that SIM card into Karen Reed's vehicle, which is something that was brought out on cross-examination by a lessee of Burgess, that was an epic fail. So what Hank Brennan's trying to do is to buttress Burgess's testimony by saying that this witness used it, but he used it in a way to assess it and analyze it and show that it leads to a lot of other conclusions. Hank Brennan comes out of the gate with the one question, are you here to testify that the text stream data indicated that there was no collision? He said, no, that's not what I'm saying. And defense is going to be saying that. Are you here to saying that a side swipe, would have registered to a text stream data? He said, I'm not here to say that either, because what the Commonwealth has done is trying to go around all the problems they have and have a side swipe that doesn't register on anything to suggest that or a clip. That's how Karen Reed hit John O'Keefe. Okay, that's what they're doing, and that is not supported by any of the data. So you can't say it supports it one way or another. But what the Commonwealth is doing is saying, okay, so this is normally, by the way, this is the data that's being used, and here, we're just going to go around that, right? We're going to go around that, and that's what all these questions are about, either to try to bump up how important Burgess is, which we all know he had problems. I can't imagine the jury forgetting all that. And then he said, I saw immediately there was a problem with the Burgess data because he was confusing megabits and gigabits to gigabits and gigabytes. He was confusing the two, and he's supposed to be an expert. And recall, he also confused the date of the accident. And he had some other mistakes in his report, along with the whole issue of the fact that, for the CVs and what has been alleged to be the phoning of the CVs to indicate that he was always intending to get a college degree over 17 years and that he couldn't get one. And then here, I don't think it lands well. Hank Brennan wants to go through a man who has both, all these degrees himself, right? He has all these degrees. He is director of engineering for one of the biggest companies that deals with data downloads, whether it be big trucking accidents or whatever, to try to suggest some way he's not qualified to render the review of the documents. I mean, this is exactly what you want to do. You want to show that what the prosecution presented and what they tried to infer from their data was improper, okay? Was absolutely improper. And notice how he doesn't go beyond what he can say, all right? He's not being argumentative. He's not being objectionable. He's not trying to do what Welcher did, which is do a filibuster. He's not giving you anything. He's giving you everything that's in his lane. I think he is a very strong witness for the defense here, because what it suggests is that the prosecution has really been dishonest in the way they presented the case. So let's see why we went to sidebar, because there was an objection. Maybe we're just going to go to lunch pretty soon. I don't know. Let's go back into court and let's listen. Oh, I see people packing things up. Are we packing things up for lunch? Could be. Let's see. I know. I guess is Jackson pulling out something there out of a file? I'm a little. There was an objection. We went to sidebar. I don't quite know. It looks like people are packing things up, right? Maybe this is going to continue. Maybe that was discussion, but do not only an objection, but a discussion as to what is about to happen in the courtroom. Aiden Carney's reporting that the tow truck operator is in the building, so maybe the defense has him lined up to go after Matt DiSogra if indeed the cross-examination does not take the whole afternoon, which it doesn't look like it really will take the whole afternoon. Hank Brennan made his point.
Jurors, we're going to release you for the luncheon break.
They called it right. We've been watching her so long. We know what she is going to do.
Address the jury.
Nope, we got the fan. We have the fan. All right, so let's talk a little bit about what happened, and then I'm going to do a mini rant and something else I wanted to discuss from yesterday. First, let's talk about what happened in court today. We have the defense beginning their case with Matt DiSogra. He is from Delta. He is from. They do one of the largest companies in the United States, considered the best on data download acquisition and analyzing data download acquisition, especially for big trucks too, because big trucks are usually in accidents. He talked about his qualifications, and he talked about how that in the data that was in the reports of both Burgess and Welcher, especially in Burgess, where he had that 5-second interval, that he didn't continue it all the way through. On all. So what DiSogra did is continue all the information all the way through, did all the analysis, very simple. How did you do it? Hank Brennan's trying to get him on. How'd you do it? He used a calculator for most part, or an Excel chart, which has which does some of the data, the additions and subtractions for you. Because he went, I guess, with Burgess when they were doing this data acquisition to be one of the people that was there, because you had the prosecution and you had the defense that was there. And he saw immediately that when he got the information from Burgess that there was a mistake in it because of the gigabytes versus megabytes versus gigabits versus megabits and all. So what he did is he just pulled everything all the way through. He pulled all the data through, and he found out, and the upshot of his testimony, he found out that there at the 1162 trigger, right, that they had, and he adjusted for the clocks, that there was an objection because the prosecutor wouldn't allow him to testify as to what percentages, that with regard to the initial time that John O'Keefe's phone was last utilized by John O'Keefe, where he manually had to grab it, an iPhone, he manually had to grab it, right? He was testimony, he was reading, he was actually scrolling through reading his messages, right? And then he was going through reading his messages. And then what happens is he has to then turn off the phone manually, okay? And that occurred at a specific time that has been testified to by Ian Whiffen. By the way, you notice how Hank Brennan try to get him to say that he's like listened to testimony or something like that. No, he just used the reports of Burgess and Welcher that indeed the phone turned off, that the triggering event is listed at 1162.2, and that that means that Aperture believes that Karen Reed had initially struck John O'Keefe with their SUV between 12:31:38 and 12:31:43. But John O'Keefe was still on his phone at the initial time that Aperture had indicated initially that that Karen Reed struck John O'Keefe. So John O'Keefe was on his phone at 12:32:16. So after we went through all the data downloads, it turns out that if you really want to be fair in terms of looking at all the data, even if you assume that Burgess had the real data, okay, adjusting for the fact that he had to take all the data all the way through, which he didn't, that in 25 of the 30 times, John O'Keefe's phone, even with the clock management and the clock vote, 25 of the 30 times, John O'Keefe's phone was being used after the triggering event on the text stream. 2 out of the 30 times, John O'Keefe's phone was being used simultaneously. And 3 out of the 30 times, John O'Keefe's phone was used before the triggering event. So if you're going to look at that in terms of reasonable doubt, the doubt is in the 3 out of 30 times. Is it possible? Yeah, it's also possible that the car shot through the moon. We heard that yesterday. But if you want to be fair to the text stream data, this is exactly, if you're using Burgess's data and assume Burgess's data is correct and you're using Welcher's data, if you bring it all the way through and you look at all of it, it's just not the 3 out of 30 times that Welcher testified to that the phone had to be used after, the phone had to be used before the impact or collision occurred. Okay, which is what they were doing. They were, they're shading their testimony to help the prosecution. Here is a witness who's very honest. He gives you all the statistics, all right? And it's more likely than not, especially I think it's within a reasonable degree of certainty here, 25 out of 30 times is pretty good that the original data that John O'Keefe was on his phone after the text stream data event occurred. Now, the text stream data event, or trigger event, doesn't necessarily mean a collision. And as a matter of fact, Karen Reed's car, in all the 19 text stream events that happened in this car for a period of time, no collision ever occurred. None of the events would occur. All right, so we have that testimony to aid the jury. I think this witness is effective because he is a stark contrast to the prosecution's witnesses and gives you the absolute truth and is using the truth based on what we know could be some problems with Burgess's download of the data because he had problems with regard to it. And he had also problems saying that the reason why he said he needed the SIM card is because he said that the data had not all been downloaded, and it turns out it all had been downloaded. So we have that, okay? And that's what Hank Brennan is just trying to draw a whole, trying to suggest his witness is not qualified to say anything. He said, look, I'm here to tell you as a data analyst, this is what the data shows. I think, and that there was a protocol deviation with Burgess because we got to the car to do what we agreed would be the protocol, and then all of a sudden Burgess decides to pull out a SIM card, out of the blue. Okay, and Hank Brennan said, "Well, that was brilliant, wasn't it?" Well, no, it wasn't so brilliant. Not when it's not an agreed, peer-reviewed protocol, and not when you can't put that SIM card in the Karen Reed's car, and not when you've already had all the information from the chips that had been read. Okay, so that's where we are. All right, I don't think, maybe I'm missing something. I don't think Hank Brennan is getting where with this witness. I think that the jury wants to know, was there an impact, right? Or was there not an impact? And the only one who's answered that question definitively is the medical examiner. Okay, we talked about that. That's why they had to go after her. Now let me answer 2 of your questions before we do the Rant. 007 in Texas. DiSogra is so great. Ooh, Hank is so gross. Very clever interplay on words. Very clever interplay on words. Okay. Yes, very good. And then to make it count, why is this acceptable? Because the judge allows the prosecution to do anything. She sustained a few objections where there were leading questions. and there was one that was an argumentative question. I can tell you, just because I'm a lawyer, I know what an argumentative question is. And she didn't need to go to sidebar for those. But she just allows this to happen. We all know that what's going on here. We all can see it. And, I didn't come into this case thinking that, but I certainly am now thinking that there is a certain bent on behalf of the judge that is not very pleasant to watch, and especially when we've been watching this case severely. Now, I noticed that everyone has asked, please hit that like button while you're on here. Please hit the like, subscribe. We have over 1,000 people on here watching. At least hit the like button. It gets us in the algorithm. We're already just past a milestone. We'd like to hit 15,000 subscribers, 15,000 subs. Doesn't cost you anything. If you want to be a member, that's a different story, but members also get some benefits. But please hit the like, subscribe, share, and notify button. Now, let me just take a sip of my coffee, and we are going to get ready for a little bit of a mini rant about the treatment of women in this whole process. And I know DEI is not something that is looked upon good right now, but here at Justice Served TV, we're going to look upon it. Let's see what we're going to talk about. But let me just take a sip. I run on Dunkin'. And it's not because that this is a Massachusetts case. It's because I run on Dunkin'. Okay? All right. So I have a rant, right? I have a rant about the treatment of women in this case. All right? And the treatment of women starts from the end of my rant yesterday with Judson Welcher, Dr. Judson Welcher, whose wife apparently may have been in the courtroom. I don't know. That's what's being reported. And when he said with regard to the medical examiner, who is a she, right, a person like that, he wouldn't consult with a person like that. That started, okay? And to me, that starts with the whole prosecution case, the denigration of their own medical examiner, who is trained, who is a professional, who went to school, who went to residency, who worked very hard to get to where she is. The prosecution has denigrated their own forensic neuropathologist by not calling her in this trial. Why they do that? Well, they decided to call a Dr. Wolf. Now, Dr. Wolf is from Florida, okay? How he got there, how he gets to this case in Massachusetts, he's not able to be certified to sign a death certificate in any state at all, unless it's in Florida for one of the patients that he's treating who dies of natural causes. And they wanted to go around him because they have hoodwinked people. And I've heard some people say, "Oh, wasn't Dr. Wolf just fabulous?" Well, he may be fabulous. He may be a great brain surgeon. Maybe if I wanted to get gamma ray surgery around a tumor in my brain because it was cancerous, I would go to him. But this is a case in Massachusetts involving a death where the state is attempting to put away the government. Let me say the government. I don't even like to call them the state or the Commonwealth. The government is attempting to put away a woman for murder. This is not any, you skinned your leg on a bicycle outside because you were riding. They're attempted to put away for murder, okay? And they've handled this case by having a buffer zone that we're going to talk about in this rant, also by keeping people away, by having a randomizer that seems to be a randomizer for some men who have a certain bent in this case, all right? But I digress early because I think the whole idea of trying to go around your women who are in this case, who are front and center with men, Welcher and Wolf, is disgusting, okay? Is absolutely outrageous and disgusting and should not be permitted. And of course, we have a governor in the state of Massachusetts, and we have an attorney general that doesn't seem to want to recognize that, because power is power, everybody. Power is what rules the United States. And the only way we have a way to go against power is to speak our voices in a way that's consistent with the First Amendment. We do not. So there's also an indication, right? Pin it on the girl. Now, initially, everyone thought, well, that's ridiculous, right? That's what you go, how can everyone be involved in a conspiracy? Well, if you're trying to preserve power, you are involved in a conspiracy. If you're trying to preserve the truth from coming out, you are involved with concealing the truth. If you're trying not to give credibility to your own female witnesses who are here and your own female experts who are here, that is a corruption of what power should be. Power should be vested in those who have worked very hard, work for the government, and tell the truth, not shade the testimony. $400,000 to what many feel yesterday is a shading of the testimony with that stupid blue paint. Well, you or I could have done that, and maybe we would have done it with pink paint. All right. But the Commonwealth doesn't have the proof, in my opinion. Not that they may not get a conviction, because we know that wrongful convictions do happen. If they get a conviction, I think it would be an outrage, but it does happen. But it's very easy to go against the girl. It's very easy to go against the female medical examiner when you're bringing in Dr. Wolf. It's very easy to go against your forensic neuropathologist, Dr. Stonebridge, by not calling her and saying that somebody else like Dr. Wolf is more qualified than they are. It's very easy to go against, to bring in Dr. Welcher, who will denigrate, degrade, and dismiss a woman who has a lot of credentials and a lot of power. Now, we have a lot of women on this channel. We also have a lot of men who are very respectful. We're going to speak up when we see something is wrong, and this is wrong. And what else is wrong? Let me just talk to you about something. We have a group here and who feel very strongly about this. And I want to talk to you about a specific blogger, streamer, that's Jessica Machado, who's been trying to bring you the truth about this case. I've never met her, okay? I think I may have liked one of her tweets once or retweeted it either through Justice Serve TV or through my own personal account. But she wants to be able to cover this trial. And now she really can't, right? Because to cover this trial, let me tell you, you don't make a lot of money. And she came into this, I think, as now a career that her kids are growing and wants to be a reporter, okay? And she tried to cover the trial, and she's able to at least make ends meet by getting subscribers and by getting donations, all right? That's going to be her livelihood. This is her new area, right? All right, Jessica, I hope to meet you someday. Maybe we'll have you on our show. But this randomizer is discriminatory. It's meant not to be, but it is. Now, who's been chosen in the courtroom every week? Well, not just Machado. She's a female. She's independent. She's a reporter. And she has repeatedly been unlucky by the randomizer, okay? Week after week after week. I think she's gotten in 2 times. And meanwhile, there is a male, a pro-Commonwealth, pro-government reporter, anti-Karen Reed reporter, who has physically accosted Jess Machado during the first trial, and she has a restraining order against him. And he's been chosen every week up until next week, as well as another a man who was a pro-Commonwealth reporter. They seem to be in more than not. Now, I have the actual graph here. We may insert it up if we can, insert it here, and we can see, let's go to, let's see, Jessica Machado, right? I think she got in week 3. I think she got in week 7, 29%, 29%. In the meantime, John DePetro, 71%. And the person who actually, Jess Machado has the restraining order again, 86%. Now, this is not a scientific analysis. I'm not going to sit here and say this is a scientific analysis, but I want to hear a woman's point of view in that courtroom. And quite frankly, I think if one reporter has a restraining order against another reporter, there has to be some common sense here. And maybe what you do is you put everybody and say, okay, for the first week, we're going to have 1, 2, the first 6. For the second week, we'll have the second 6. The third week, we'll have the third 6. The fourth week, we'll have the fourth 6. Okay. The fifth week, we'll have the fifth 6. Okay. All right. That's, and I'm not going to go beyond this because you get my point. You're getting my point, and all of you, when this rant goes up, will be able to comment and put in your points with regard to this. But come on, you know what? As a matter of fact, I just learned that Stephen Plort will not be able to be on the air tonight. I'd like to have Jess Machado on the air. I'd like her to come in and talk to us about how she feels. I'd like her point, even though she couldn't be in the courtroom, about the evidence that she can see from far away like we can see it. I really want to know what the jurors are doing. Now, Aidan Carney is in the courtroom today. He is telling you what the jurors are doing. But I want to hear it. I want to hear it from somebody that I can go shopping with, that I can have a girls' weekend with, okay? All right? Now, yes, do I know reasonable degree of scientific certainty? My rant is not based on a reasonable degree of scientific certainty. It's based on my personal opinion. It's based on how I feel, and it's based on what I think is unfairness and all. And that, by the way, ignores the fact that even us and other people who are reporters, who actually sued for the First Amendment right to be reporters in that buffer zone, is not considered by Massachusetts courts to be reporters. That eliminates a whole group of other people. A lot of them are also streamers like we are in this network, okay? So it is ridiculous, it is outrageous, and I think that at some point we have to stand up and say, the court systems have changed. And it did change this morning, because I just tweeted to you a picture that Aidan Carney actually had tweeted. That is a bunch of Karen Reed supporters who were able to stand right at the courthouse steps in the buffer zone. Why? Because you had strong people like Erica Walsh. You had strong people like Jason Grant. You had strong people like my pod partner, Michael Bryant. You had strong people like Tommy DeRosa who decided to go against the government. And luckily they found, whether you like him or not, they found Mark Randazzo. They found the Center for Liberty. They found Mr. Royce, who's been on our show. It's unbelievable what's been happening here in Massachusetts. I am shocked, because when I tried Hernandez in Massachusetts, it was wonderful. They did a great job. They were wonderful to us. They couldn't be more accommodating to us. But we were defending a guy, right? We were defending a star football player, right? For a double murder, which we had an acquittal in, even though the jury knew that he had been convicted of murder. Here, it's a different situation. It's a small courtroom. It's a small, powerful group of people. And we see what's happened. And I haven't even mentioned to you the Sandra Birchmore case. Okay, I now just mentioned it. There has to be some remedy to make sure that justice is wearing a pink cap, all right? That justice is something that is fair, and that justice is something that the rest of us want to see. And quite frankly, I want to see Jess Machado in that courtroom. If she can come in the courtroom, I hope she comes on our show tonight. That's the end of my rant. Okay, all right. We're going to, I think, let me see if there's any more questions. If not, I may take a little bit of a lunch hour and have some of the videos being played. By the way, Michael Bryant will be on the show tonight. By the way, let me just say before I go, the issue of reasonable degree of scientific certainty is a real issue. California does not require witnesses to testify on that because it's bullshit, right? Reasonable degree of scientific certainty. What does it mean? If you have an expert on the stand and you say, what's that percentage under the law? They won't be able to tell you. They won't be able to tell you. In some places, it's 51%. It's 51%. A reasonable degree of scientific, it means more likely than not. Consistent with is bullshit, okay? Consistent with means something could happen, something couldn't happen, okay? So reasonable degree of scientific certainty is absolutely a ridiculous standard these days. It's just like everyone says it, a reasonable degree of scientific certainty. Massachusetts tried to do something about it by having the Hang case. Commonwealth versus Hang on ballistics is saying people can't talk about that when they aren't real scientists, right? They really can't talk about that if they're not real scientists. But that's not that case in Massachusetts here right now, because as you heard, Welcher tried to bandy that about yesterday with nothing coming from the judge about that, even though there was an objection, I think, and all at some point. So how many press seats are there? Well, let's see. I thought there was 6. Diz can correct me. I thought there was 6. And then if you're not there by 10 a.m., I think then you can be on the alternate list, right? And the alternates can get in. And that's how I thought Jess Machado got in one day because she was an alternate. I know Sue got in because she was an alternate yesterday. And she actually told us what the jury was doing, right? Reporters should be reporters everywhere, okay? Reporters should be reporters everywhere. Micah says he thought it was a 0.05 required for the court. No, it's not defined, and every state is different, and most states don't define it. In some states, even the federal court doesn't require you necessarily say that. It has to be your opinion, and your opinion has to be valid based on Daubert, all right? And then what you have is an error rate, okay, or you have a confidence rate. And that's also something that most experts don't understand. So when you see lab people testify, it's because part of their accreditation process requires them to have error rates in what they do, and also a confidence level in their error rates, okay? So they may say, look, I'm giving you this opinion, but my error rate here based on all the testing I did could be 5%, or it could be 0.5%, or it could be 10%. And I'm and I have a confidence level of 91% than my error rate. So at least the jurors have some idea of what a reasonable degree of scientific certainty is. All right. So But it's a mishmash. And the jurors take it. The jurors understand what's going on here. Well, I hope so, because we all never knew about tech stream events and triggering events. Last time we heard about key cycles, but we never heard about all of this like we're hearing it today. In any event, to me, the important part of this is that there's no collision. There is no proof beyond a reasonable doubt that there were ever a collision, period. No collision, not guilty. No collision beyond a reasonable doubt, not guilty. You don't need an error rate. You don't need scientific certainty. You don't need a confidence level unless the state proves it beyond a reasonable doubt. Now, that doesn't mean you couldn't have a wrongful conviction here, because unfortunately, they're all over the United States of America. Just look at the Innocence Project. I'll tell you one other thing about the Innocence Project. I'm proud that my husband last year received the Justice Award from the Innocence Project for all the pro bono work he does over his career for people that have been wrongfully convicted, and that he's helped get them out of prison, and he's testified when necessary. Okay. People rag on experts because sometimes they make money. Well, their money sometimes, unless you're apparently Aperture, funds your wrongful conviction work if you are somebody that wants to do the right thing, as Michael Bryant says. Okay. With that, I think, when is court coming back? Let me see. It should be in court is on lunch hour till 2 p.m. So about 45 minutes. I'm going to have Diz play some things. I don't know whether we can replay one of it. Oh, yeah. Just before you go, I think we have another start question. I think we have another question here. I see. Yes, Michael and Bryant is in Portugal at where Madeline McCann. He is doing an investigation for us, especially given the new amount of money that was advocated or allotted in England by Scotland Yard to continue to investigate this case, which was terribly investigated from the beginning. He is right there, right exactly where she was kidnapped. And of course, when he does the show, he will be 5 hours. He's doing it at midnight because he is a reporter with an Emmy. And quite frankly, Massachusetts, that's what you needed to cover this case. And we're so sorry that you had to exclude everybody from the buffer zone, and we had to substantiate our rights in the buffer zone. Just go look at those pictures. And when you ever think that your constitutional rights aren't important, they're important for you here, even if you're sitting at home watching this trial, because without those constitutional rights, you wouldn't know what is going on. So stay with us. We're Justice Served TV. Dizzy's going to play Aiden's video after the rant, you all, and I will be back if it's okay with you. Okay, if it's all right with you, I don't want to leave you, but if it's all right with you, I want to get some of my other legal work done during the lunch hour, and I'll be back when they're on the air. And thank you for our great moderators for staying with you and giving you, I think, one of the best channels in YouTube covering this trial from morning to night, even night in Europe. I'll see you soon.
Nobody didn't get it yet. Oh, I didn't Oh, yeah. Nobody didn't get it yet. Oh, I didn't
I'm going to turn this over to you because we have a very important guest on. You know him well. He's been on. He's friends with Dr. Welcher. Don't. That's okay. It's all right. It's okay.
He's
everybody.
a professional
Don't go
friend.
out. It's a
Yeah.
professional friend, just like we have professional friends have different opinions. He's been on the same side with him. He's been on a different side with him. But his experience, my gosh, and what he told us about making sure the crime scene was good last week, and how you had to do it. And this crime scene wasn't great. Was just what can I say? It's just wonderful. And he's a brother of a co-counsel of mine from the Phil Spector case. His brother Chris Plord is now the senior judge, the top judge in Imperial County, San Diego, where you're familiar with. Knows forensics inside out. The family is great. They're honest. They're honest as you could be. What can I say? Have morals, have ethics. Isn't that somebody that you want doing your forensics? Kyoko, thank you for that.
Hey, Stephen.
That's
How
a
you
great
doing, bud?
build-up. Thank you very much.
So welcome back. It just
Thank you,
seems like
thank you.
days ago that we had you on. We had you on the eve of what we were anticipating from the the Aperture expert, Mr. Welcher. Now we've seen him. You've seen him. Give us your thoughts.
Well, he knows what he's doing, and he's good at what he's doing. He just didn't go far enough, in my opinion.
How so?
Well, he did his grease paint test for one, and he's looking at the evidence of the arm, the forearm, and where there's contact with the lens of the back tail light, and he had the vehicle back up at a certain speed. I think he said 2 miles an hour. And he held his arm in the exact right spot where, and this is all pre-done ahead of time. He knew where it was going to touch. So he wanted to make sure the contact and the scrape marks and the contact with the lens all match up. And that's something you would do, but he just didn't go far enough, because I don't think that just because it makes contact there, it is going to leave all kinds of evidence on his arm or the taillight itself, because the allegation is, or the evidence from the police showed, that upon contact with the taillight, it broke and it went on the ground at a certain spot. And nobody can identify that. And where it is on the ground, it would clearly, you saw how deep the scratches were, how deep the lacerations were on the arm. If that lens actually was unfractured and then fractured as a result of the impact, I would clearly see evidence of tissue and or blood, some DNA on the lens itself. And there'd be a lot of it because it broke in multiple different places. So when it did that, they said, I don't think there's any DNA on the lens that we know of. Is that correct?
There was some
I'm
John
aware-
O'Keefe on the exterior portion, certainly nothing on a broken part or the interior part of the lens.
Right.
And no flesh, no blood, no
tissue, no nothing.
You saw those are a lens that fractures, and then it causes deep cuts and abrasions and lacerations such as that. You would expect to see, first of all, you'd expect to see flesh on it, because when a car gets hit or a person gets hit by a car, there's all kinds of tissue you find embedded in the windshield, the fracture of the windshield, or the lens, or the hood of the car. There's smears all over the car, and there's all kinds of DNA, and the physical evidence is there to show all that. And there isn't enough there. The other thing is, I don't think that the lens would fracture that fast, even at 20 to 24 miles per hour, to cause all the lacerations all the way across the arm and the forearm. The other thing I noticed, and he indicated the same thing as the ARCA experts did, as the arm is stuck out there, only was 8 or 10% of the body weight is on the arm, or less than that. As the body spins away, now the body is rotating. His test where the head goes smacking to the ground, if he's anywhere near the street, it's going to fall into the snow, but it's spinning and rotating. The laceration in the back of the head appears to be a straight, blunt hit backwards, not a rotation, in this case, a counterclockwise rotation when it hits the ground. And it's going to have different characteristics. And even though I'm not a pathologist, you got to look at the pathologist reports. You got to look at that. You got to look at the autopsy report, autopsy photographs. You may say, I disagree with it for one reason or another, based upon my experience, this and that. But I looked at it. I looked at the report of Paul, Detective Paul, or Investigator Paul. You look at all that and you kind of figure out why they're different than me. Maybe they're inexperienced. Wiltshire has good experiences, no doubt about it. I met him in the early 90s, mid 90s, and I'm not buddies with him, but we're on a first name basis. I can call him up on the phone, ask him a question. We'll talk to each other at conferences. We'll see each other on same side cases or on different side cases, and we'll agree or disagree. But he's in a different field. But the bottom line is, I don't think there's enough evidence to support that the impact took place at a certain spot. Wiltshire did some things that he was talking about how the car went forward 34 feet, then backwards 57 feet, total of 87 feet. The total distance up and down was 47 or 87. The thing is, it's doing 24 miles an hour at that point. At 24 miles an hour, it's going to continue backwards for another 20, 30, 40, 50, 60 feet. And there's a vehicle back there, depends on where it was, it's going to be hit. The Jeep or the Ford F-150. There's just too many unanswered questions. So he did a reasonable reconstruction, but he left out too many things. If you're going to buy a vehicle for $50 or $60 or $70,000, and some people have the ability to do that, you get a dummy arm that weighs, and you either slap it as hard as you can, or you hold it out and you hold out the dummy's arm and back it up at 24 miles an hour to show what type of damage it will do. Can you do it with 3 or 4 cars? Taillights, a couple $100, $400 or $500. Do it a couple times.
Yeah.
Don't have him do it. I wouldn't want him to do it himself, even though he was the same height and weight. He did a reasonable analysis, just didn't go far enough.
That was one of the things that jumped out at me as odd, amongst many oddities, is that, hey, let me just, I'm going to be auditioning for the role of Officer John O'Keefe, and then I'm going to fill that role. It's just weird. If everything else were pristine, I would still question his objectivity when he is that big a part of the experiment, which Attorney Alessi focused on quite a bit, and that is, these were experiments. This is not sort of fact-based, reliable science. You're just goofing around here. You're experimenting to see what might happen.
Right. He's trying to recreate what he thinks happened. And is he working for the prosecution? Yeah. Is he being fair and objective? Probably not, because there's a lot of pressure on him and the state to convict Karen Reed. Because like I said before, I'm pro-cop. I don't want to see the cops put out evidence that looks characteristics such as this. It does look fraudulent. It absolutely, the way the investigation was held. But you got to look at it and be more objective, in my opinion. And I don't think he was as objective as he could have been. Is anything possible? Yeah. Is it reasonable in this case? Probably not. But there's just not enough testing that was done. And he, he knows what he's doing on the stand. I haven't seen him since he had his full beard. This is the new beard.
When we introduced him the other night, it was his Aperture, biopic, and it was clean shaven and actually a little heavier maybe than he was when he appeared on the stand.
Right.
Yeah,
I saw him a year and a half ago at a conference, and he was clean shaven and a nice guy. He's always been a nice guy to me, but he looked like the beard makes it look more, I guess is the word, distinguished, more professorial. I know that's my theory. Yes. And that's why I color my hair white now. So I look. when I first started 35 years ago, they said, "You look really young for having all the experience." Because my hair was brown, I was actually a little bit thinner. I just didn't look like I knew all that I knew. Now I got more experience. I got the gray hair. You put a different type of glasses on. No glasses, sunglasses. So you have to fit the part to let the jury make you more believable. And he wasn't looking at the jury as much as he should have, but he did okay for what he was supposed to do. But I just don't think he brought it home. I really don't think he brought it home.
Yeah, one
you
of the
need-
questions I had, Stephen, is the we're all looking at the broken taillight. So how much force do you have? Bring that car and show us how the taillight breaks. Back it into something. Back it into a crash dummy. I mean, I've seen these crash dummy tests. Why isn't that done? I mean, we bought our own taillight. You saw it I don't know if you saw last week. We bought our own taillight for what $400, Michael?
Oh,
Right.
shoot, no, I got it for less than 100. All disclosure here, the top corner of it had a piece that had been broken out. Didn't affect our experimentation because we still took a hammer to it to get it to break into pieces.
I mean, that's a heck of a beating to get it to break
Yes.
like that.
Yes.
And not just a small part of the tail light, didn't just crack it. It fractured it into now 46 different pieces.
Yes. As of today, 46. Yeah.
Unbelievable.
Mm-hmm.
And as I said the first time, when the officer first showed up at the scene, who knew there was a dead or dying officer, police officer, and another officer or detective's home in their yard, you shut down the whole scene. Whether the leaf blower works or let it melt and just let it dissipate a week later. Who cares? There's too many unnecessary. And the other guy from Aperture, what was his name?
Shannon Burgess. Shannon with the one end Burgess. Oh,
these guys, Welcher and Burgess, they just came up with a dynamic team that left no stone unturned and did a great job in cross-examination. And we'll see what happens to the jury. I think the defense has a decent shot for, in my opinion, of acquittal. But you got to look at all the reasonable doubt. There's certainly a lot of reasonable doubt here. And I know if all the Aperture people, not Aperture, but the ARCA people, if they bring in Proctor and Paul and even Higgins, they're going to make things look like they're really trying to hide something. But I don't know where the defense is going. I know they're all on the list of the defense list, but you don't know who's coming up.
Yeah, and starting with Matthew DiSogra tomorrow, who is going to have qualifications in being a biomechanical engineer. So that's where they're starting. They're going right at what was left off today, going into the weekend.
So the ARCA guy that was
no, he's not. He's not ARCA. He did the downloading the data and all that type of stuff.
Oh, okay.
Yeah.
I mean, there's so many things that are different on that. And as the vehicle backed up for 53 feet or so, 57 feet, and so it had to start at 0 and go back to 24. Where in that pattern, in that path, did the vehicle actually make contact with the victim? And nobody
did. If the vehicle did, if the car did.
Of course.
Exactly.
Yeah. And you make a good point. I mean, this is a magic Lexus that once it made contact, it immediately stopped. Or did it make contact? Let's assume it went from where John O'Keefe was standing forward 34 feet, back 53, because it was 87 total. That means 19 feet from where he was standing. So then did it hit him and then continue to travel for 19 feet?
It had to go backwards further because it's still going 24 backwards.
Yeah, even after the contact, right?
And the other thing is, what is he doing standing on the edge of the road? He sees the car go forward, then he sees it come backwards. In that 8 or 10 second timeline, why is he just standing right there? Is he just? There's too many things that we don't know. There's just so many things we don't know.
And that sounds like reasonable doubt to me.
To me, it's reasonable doubt. And I didn't mention this last time, but my dad was a very prominent criminal defense lawyer. And he followed in the footsteps. My brother Chris followed in his footsteps. I went to law school for a while. I've been around lawyers for a long time. When I was with the Highway Patrol, I testified. Now I do mostly criminal defense on my criminal cases, but like 90% is civil cases. But it's all the reconstruction is the same. But in this case, like we said before, you're trying to put Karen Reed away for the rest of her life. You have to leave no stone unturned. You have to have the most immaculate investigation. And in this case, to me, it's just not there. I don't know if they're going to be able to do that. I don't think they're going to be able to do that. But just because she's there, he's dead, and we want somebody accountable, and nobody else is going to fess up to it, the jury may come back and find her guilty.
Yeah, we talked about that.
Yeah, I don't think it's going to happen, but it could happen. I'm saying it could happen.
You never know what a jury's going to do, and that's the danger here, because we know all this stuff, but you never know what a jury's going to do. Just like me, I got turned off by Welcher. Once he said that was it. I'm not taking anything he says. But didn't that look more like a reenactment for TV that was done, as opposed to an actual reconstruction that you can test? You can subject to peer review. You can repeat it. You know, the repetition, scientific repetition, as you know, is important. To me, that seemed more like a made for TV reenactment, as opposed to an actual.
And I think it was. You got a surrogate person. You got an exemplar vehicle. You know where the damage is on the arm, the injuries to the arm. You know where the damage on the taillight is, so you put blue paint on it, and then you back it up to match it just right, and then you got nothing else to follow. He said the taillight could break at 8 miles an hour. I seriously doubt that.
I do too. If that's true, show me. Show
yeah.
me. Show me that.
You can get a surrogate dummy that has the same 10 or 12 pounds and slap it as hard as you can into the taillight and see if you'll break it. And I don't think it will. I really don't.
I don't think so either.
And quite frankly, we don't really know if that was done. I mean, one of the things that you don't get, and when you, as you know from your brother, you don't get the stuff that is bad for you when you do this. They only turn over what is good for you. Maybe not you, but we've been in cases where then you find out that, wait a second, they said the gun trigger pull was 8 pounds. Or it was a hair trigger, 1 pound, but they did 500 tests and only one time did it go off. Every other time it was not.
Sure.
And you find that out after years of litigation, after somebody's been convicted.
Sure.
That's what I worry about. Yeah, that's what I worry about. Anyhow, while we're watching this, we have some viewers. I gotta know. Watch All Daily. Thank you for covering everything. We appreciate you watching us. We try to bring you good guests. We try to bring you guests to know what they're talking about. That way you have a reason to come here. And Paramitas chipping in towards Mike's Bean Burrito, because you're on the road. Everyone knows that you're going to go back down to, we're here, but next week you will go back to Dedham. And then Donnie Nat Wahlberg is one of our big supporters. It's really disturbing that Proctor said you should have let me talk to her. That's talking about, we're going back to the, I've kind of lost the comment. It's really disturbing that Proctor said you should have let me talk to her. So did he think he would change her report? Has he done that before? And that's talking about Dr. Scorty Bello, because he called her a whack job when she wouldn't say that this was a homicide, okay? Oasis Cat has a question, Stephen. Have you ever gone out to buy the exact same clothes of the deceased and wore them in a demo?
I have. I've bought similar clothes for visibility and conspicuity issues at night and so forth, what you can see and can't see. But I have done that. You try to do a surrogate and do a reenactment. You want to match up. Let's say you're in a car with that has a seatbelt or no seatbelt, and you want to show if the seatbelt is properly worn, not worn at all, where the body moves within the car. You get the right size person. You look at the clothing, because there's certain physical evidence on clothing, especially with the pedestrian impact. They're going to land on the ground in a certain way and get hit. But the answer is yes, I've done that. I haven't personally. I've only done it once personally, because I'm not the typical person that gets hit. You find the right size surrogate with the same weight, hair color, hat, shirt, pants, boots, and you do that type of reenactment.
For visibility, though, that's more for visibility, right?
More of a nighttime visibility and stuff like that. What you can and can't see at night. And we rent out cars that are just like the ones that we have, the same year, make, and model. We just did one earlier this week. And you show what the lighting from the exact same set of headlights, where the driver was, how high the eyes are, what you can and can't see, to show or disprove certain aspects of the case. And we do that all the time.
Yeah. There was a point in Welcher's testimony where he's trying to explain the cut over the eye, and he's talking about it lining up with an airfoil, air dam spoiler that's really kind of at the top of the vehicle. But it seems to me that if all these other things took place, all these other contacts to the arm, that at that point his eyebrow level is going to be nowhere near the spoiler on the vehicle. It would be a bizarre scenario in which both of those things happened at the exact same time, don't you think?
I would think that, because the way he was situated in his body, his head is inset of the spoiler itself, and I wouldn't think of making contact. But if you want to push yourself and try to line it up because of his height, where the laceration was in the top of his head to the spoiler, you can make anything work. And for demonstration purposes, he did what he needed to do. He says, yeah, everything seems to match up. So these things are all possibilities, but you have so many different probabilities, so many things. And as I said a few minutes ago, when the body gets hit and it starts to rotate, he's not falling back on the back of his head. He's spinning and rotating by the time he gets to the ground, and he's going to roll and he's going to spin a little bit. And to get a laceration in the back of the head that is demonstrated in the photographs just doesn't seem consistent with that. It would be nowhere near the curb. The fire hydrant is surely maybe in play, but there's nothing there. And nothing was documented at the scene. So there's just too many unanswered questions, in my opinion, to put it all together. And even Welcher said it. There's not enough evidence to show how he was moving prior to, but to line it up perfectly with the matching with the tail light, he did a decent job in that, but like I said, he just didn't go far enough. And there's too many unanswered questions. And the GPS data and the navigational system, the speed analysis, there's just too many things that just don't make sense.
I got to know, says no data on force to break the polycarbonate. That's exactly what we're talking about. Thank you. I got to know. We think they're absolutely right. And then Ryden Bowen wants to know, my favorite was when Welcher said it's possible for the Lexus to have flown out of space. Sorry. That was,
I guess in theory.
He's being facetious, but it makes him sound like, well, whatever I'm saying also is just as facetious. I don't know that it helps him. Hey, Linda, here I got an idea. I want to, I'm big on doing these experiments, so I'm going to back 8 miles an hour into a tree, and just see what happens. So I have a question for you. Can I borrow your car?
It's not the same car.
That's okay. We're just testing the polycarbonate lens. Don't worry so much.
But maybe a different polycarbonate lens. Super generous. Okay. Right. Let me give you a couple comments here. So general lens. Thank you, Lyndon Michael. The Sui's always very gracious to us. Pro Gamer, this is interesting. I hear Aperture stock has tanked. Are they a traded company? No, they're not. They had an IPO that they were going to do back in 2022. They pulled that IPO. So one of the things I had wanted to know, and I'm not going to ask Stephen this, is whether or not in the industry is there rumors about whether Aperture was going to do another IPO based on their, shall we say, their fame in the Karen Reed case, which hasn't worked out so well.
The timing on that's, it's interesting. Before Stephen answers to the degree he can, that was at or about the time that they started gobbling up these smaller entities like
2022,
right?
Right.
And like Burgess. So that might have been all part of that mix. Whatever you know, Stephen, if you could share.
I don't know. I know I work with many reconstructionists, and Judd Welcher, 4 or 5 other people, I won't mention their names, but I knew them all as their individual companies. And I worked with them and against them for many, many years, saw them at conferences for the last 20, 25, 30 years. Then all of a sudden, Aperture bought, right now, I know the 5 owners that were now purchased by Aperture. And I understand they got pretty good deals. And even Judd said, it was a good deal for me. So I went out and let Aperture buy me. And now they're all under one umbrella, and there's 15 companies in Texas and somebody in Boston. And I know people in Los Angeles, Orange County, Las Vegas, Texas now, and then Arizona. I know these guys personally, and they're all Aperture, and they all work under the same umbrella. And I wouldn't want them working on, well, if they want to buy me out, they can, but I don't have a big company that has 8 or 10 employees like most of these guys do.
Well, actually, what does Mr. Plord think about the morality, Kay from Kaylala? Welcher's testifying the way he did and making definitive statements about a collision. Thoughts?
Well, I think that he has to say that because that's what he wanted. He doesn't want to say, I don't know what happened, but this is more likely than not. And based upon the testing, everything matches up. Well, the injuries match up with the tail light, but the rest of it doesn't match up. How,
And that's because they made him match. It was clearly made him match up.
if somebody's going to pay me $325,000 as a whole, and I buy a $60,000 vehicle, and I can do what I want, and travel back and forth across the country a couple times to do some experimenting and testing, there's some things I would have done a little differently. But you know, he got involved in the case last September, I believe, so it's only been in about 9 months.
Yeah.
But you know, he's trying to do what he has to do to show that they have a decent case. Does the evidence match up? Sure. Some parts of it does, but more of it doesn't match up.
Doesn't match up, and that's the problem. Let me go through some of the Amy's positive pathways. Member for 2 months. Can jeans really scuff the vehicle, Stephen?
The answer is yes. If it's going fast enough, it can. If it's wet or there's snow on it, it may not be able to stick to the surface. If it's a different color, you'll see some patterns of jean imprints on a vehicle if it's hit just right, if you're wearing jeans.
Yeah. And what would fast enough be?
You're probably 15, 20, 25 miles an hour.
All right.
But, you know, if you have snow on it or it's wet because of the conditions, my thought is you probably won't get a transfer.
Interesting. That's really interesting. So you got a lot of questions here. K squared. I can't get it past. Well, I'm sorry. Race Rocco Franco. Do I have K or do I have sui generis? I have so many people. I have so many people here. Sui generis. Thank you, Sui. I want to thank you for all your donations and getting your questions answered by Stephen. My brother was tough man boxer for years. Fought Tommy Morrison for Rocky movie. Wow. I showed him JLK's face picture and asked him what happened. My brother said he was beaten to death. And he, do you, and this is maybe unfair because this is what I ragged him on today. Thank you, Sue, by the way, is that, you know, you have to collaborate, right, with the medical examiner if you're going to see that, I would imagine.
Sure. I mean, you don't have to, obviously he can't agree with the medical examiner and say, I don't know what the cause of the injury pattern was, because the pathologist, I don't know what the injury cause of death is. Blunt force trauma, the laceration to the head. I mean that's, to me, that's obvious. But what caused that, the causation of the injury, medical examiner says undetermined. And the judge said, well, no, I don't trust those guys or believe those guys, so I disregarded it. And I say, well, it's consistent with this type of impact.
Blessed in Texas, national portfolio of best-in-class forensic expert companies providing a full-service expert analysis. CAC Forensics Partnership, October 2022. I guess that's the company that was bought. His company that was bought was CAC. Do we know, Stephen?
No, Judd had his company was in Long Beach, and I can't remember what it was. It wasn't that. It wasn't CAC. But, you know.
Yeah, there's definitely a period that they were absorbing anybody they could, it seemed, right?
And then a couple other people are being bought out by other smaller companies or larger companies to make their own network of experts. They want to be a one-stop shop. You got an expert for this? Yeah, I got this.
Right.
You have an expert for that? Yeah, I got an expert for that. And they have all the same ideas, and here's our pattern. And these guys make a lot of money.
Well, we know that. We know Welcher's pushing $400,000 on this case. $400,000.
I think there's 3 or 4 offices working it, but you know, there's a lot of testing. There's a lot of work. I know how much money he makes per hour when he just does it per hour. When he's testifying, it's probably twice that because it's more. Your testifying fee is like double your normal reconstruction rate. And he being out there last week, he flew out there, and he says I was supposed to testify earlier in part of the week. Did he stay out there for the whole week, or did he fly back?
I don't think so. He said, I think he went back.
But you know, I saw some pleadings in another case, totally unrelated, in which somebody was contesting the money that he was paid or billed because he had reviewed tons of medical records and things of that. And the court decided he didn't need to look at those medical records, and they basically whacked his bill. I think it was $16,000. And so, you know, I'm not saying that overbilling is unique to Welcher or his company if it did happen. The judge found that it did, but it does just make you wonder, amongst all the other issues with this guy, is he also padding?
Yeah, well, a lot of medical records will have little excerpts of certain things in them that may be pertinent to your investigation and your analysis. So you may have to review a lot of them, but you don't have to review them to the depth of, $50 or $60,000 or whatever it may be, or even, and like you said before, $16,000 on that bill. But I get a lot of material I have to review, and until I review it, I don't know what the answer is, and maybe it's good, maybe it's bad.
Right.
Not enough evidence in there, but it could
So,
be a point or another.
Rocco Fracca, I'm the only one who saw reflections of the sky and trees in the bumper on the Lexus when Leslie was comparing the 3D scans of the vehicles Photoshop. There was a question about whether there was a Photoshop or a 3D scan. How can you tell the difference?
It's hard to tell. You have to look at the photograph itself, and I have to look at it on a computer. And I can't say, scanning it, and you're going to leave, like he was talking about today. What is in the background?
Oh, just local drunks.
That's in Portugal. And that was a sad case of that little girl.
It's horrible.
It's
horrible.
It's awful. I remember I followed it for a while.
Yeah, and it's still alive.
But the answer is, sometime when you scan it, certain parts of the car don't scan properly, like the chrome pieces, the black doesn't scan just perfectly. And if you look at the photograph and photogrammetry and put it all together, you can tell. But
yeah,
he's saying it's not, and I don't know if it was or not. I don't know.
Let me ask you this about the whole 3D scan thing, which is all very science fiction-y exciting. I get that, but it seems to me the key purpose for it is for measuring distances, to make sure you've got specifics on distances as it relates to that vehicle. And maybe I'm misunderstanding the purpose, but it didn't sound like he got much out of that, if that is the purpose.
Well, the reason he did it, from what I saw when he testified, I think yesterday, he recreated the backing of Karen's vehicle into O'Keefe's vehicle in the parking lot of the driveway to try to perfectly match up where the vehicle went after it got bumped. Was the bumper and certain parts of the car aligned? Did the bumper or did other parts of the car make the taillight crack? And I think that was the whole purpose of that, to see if the taillight broke in that backing up, or like somebody said, she said, I backed into John's car and I broke the taillight. How would she know that unless she went out there and looked at it? And
I think she did. I think that was the issue. She said I had,
at some point she did notice it. To me, it's a little unclear as to when she first noticed it, of course. But to me, in Welcher's testimony, he basically said she did not. We acknowledge there's contact, he says, because we see it in that video. But he says the taillight was not cracked, because their goal is it's all or nothing when it hit in their position of John O'Keefe. So they were, but I don't know if that helps them all that much or not, to be honest with you, because
well what they do, they scan the scene of the driveway, they scan the Chevrolet Traverse, they scan the Lexus, and they're able to show it into 3D motions, and they put it into a program and back it up and match up the video, and as they came in contact with each other at this certain point, and they say when it hits, the bumpers are touching, but the taillight is nowhere near there. And I think that was the whole objective to that.
Fine. Yeah, but it's an argument, but I just don't know if it gets them where they need to go. I just don't.
Yeah. Blessed in Texas apologizes. Sorry, Linda. CAC was Burgess in South Lake, Texas. Their website says Aperture is a partnership of companies, but they are an LLC. I don't understand that. Do you have any insight on that?
I do not. They were a separate company before Aperture bought them 2, 3, 4, 5 years ago, whatever it is.
You'd have to see the documents between those companies and who's holding harmless the other for liabilities, as this pre-existing. So if you absorb Welcher and 3 years ago he screws up on a case that leads to liability, this new company wants no part of that. So there's going to be some paperwork that cuts off their liability from pre-existing problems he may have caused. That'd be true with any business, not just him.
Yeah. K Squared has an interesting comment. I can't get past Karen having multiple drinks, slick service from weather in the dark, and back up all the way, and maintaining control of the car. I don't know. The whole thing is, I mean, you've ever tried to back up? I don't know. I can't back up 24. How many feet was it to back up straight?
Well, it was 54 back.
Yeah.
Well,
Yeah.
that's what's documented, but it's still going backwards at 24 miles an hour. So it has to continue until you put your foot on the brake. And my understanding is the foot's not on the brake at that point, so it's going to continue for another 2, 3, 4, 5, 6 seconds. I mean, she could be down in the other part of Canton, but
she'd be to Crestview by then. Yeah.
That's impressive. Hear me. 400K for Aperture, a lot. At minimum, 300K for Brennan, 700K extra money for other things. Won't
Norfolk
use the
County
resources.
DA,
The Norfolk County DA won't use the resources they have already. Lived in Norfolk County 33 years. Vote Morrissey out. That's a political statement, and that's the feeling, Stephen. That people there, we as we've gone into this case, they've had enough. They've had enough of all this. They don't see competence, and Karen is this, to use a lack of a term, she's a vehicle for the fact that they feel that she's being railroaded. Because why wouldn't you just tell the truth? Why don't you bring everybody in and just tell the truth? That Paul had a different opinion, that this guy has a different opinion. The medical said, bring them all in. Let the jury find out what's going on.
I mean, he was on hand. Paul was there that day, and he came up with an analysis of what happened. Now there's more information, and Paul's information is not good enough, so they bring in Welcher, and they bring in Brenner, and now they come up with something here and there, and right, like I said, the DA's office wants to convict Karen Reed, and they don't care. They don't care the cost. This is just one expert, one set of experts. Welcher's office was contacted, and he contacted probably the guy in Texas that worked on the case, and their team went together and put all this and Eva's stuff together. But they're $300,000, $400,000 or more, because that's, I mean, it's a lot of money. There's dozens.
That's a lot of money, right?
There's a lot of money.
Before we let you go, 007 in Texas. Speaking about Texas, what are your thoughts on his attitude, Stephen? Because you're just wonderful. I mean,
well. Some of his testimony was straightforward, but he was somewhat condescending, and he's being a smart aleck a little bit, because he was nitpicking at some of the way he answered, like Lexus. He was talking about what was the word? Appendectomy or something. I can't remember what he was talking about, but he said something. It was Lexus, not appendix, or something to that effect. And everybody knows he's talking about the Lexus and a car, not some type of anatomy or body part. But he is trying to be clever, and he's a smart guy. He knows what he's doing. And just like I said, I think he probably turned off the jury at certain parts during the cross-examination.
I think there's no doubt about it. I mean, they don't like to hear a smart ass, and they don't like to hear a guy that won't admit when something may or may not have gone as he had hoped. And
Right.
he just would never back down. He was always smarter than Alessi. So I think it comes off badly.
Well, I'm an engineer. The car could go to the moon. In reality, it could go to the moon, but to say stuff like that, it just doesn't sound right. And I don't know if he's going to watch this thing at some point in time and say, "Steve, what are you doing there talking about me like that?"
He should be lucky that I didn't cross-examine him. That's all I can say. Stephen, we're gonna let you go.
Okay.
We hope that you'll come back on. Obviously we have some of this stuff beginning, and the ARCA people probably.
Yeah,
next
when the
week,
ARCA
and
people come on,
we
that
hope
would be
you'll
great.
be on with us for say the whole hour. I know we try not to use your time as much as we can.
Whatever you want.
All right, don't say that, because we will abuse you. So don't say that. We will bring you on here.
Well, my brother Chris, he always says sometimes you just gotta do what's right, and even though you don't get paid, you do it right. Some cases with the Innocence Projects, I did work for no charge because it's just the right thing to do, or you don't charge as much because some of these criminal people just don't have the money, but they got to have the proper representation and the evidence to point out the exact things that you need to do.
Thank you, Stephen.
And getting experts like myself, I'm not as expensive as Welcher or the other guys, but I'm almost about half of what these guys are.
Thank Crash Lord Plord. Okay, 007
Yes.
says thank Crash Lord Plord.
With my experience, 3,000 times at an accident scene as a CHP officer, firsthand, seeing within minutes the evidence, then 6,000 plus times in private practice last 35 years. I think I know what I'm doing.
Sounds like
We
it.
do too.
Yep.
That's why we have you on.
Yep. And we appreciate it, buddy. We will be in touch. We'll have you back on. Thanks
See you
again.
next week, we
Thanks.
hope. Well, I'm back, all of you. Thank you very much for hanging here with us. I see we didn't gain people. We didn't lose people. I hope you enjoyed listening to Stephen Plord from our last night's episode. I think it was good to listen to him, especially in light of hearing today Matthew DiSogra. I think I'm looking, I think you all pretty much liked him, right? You all pretty much liked him. Yeah, let's see. Well, it's 2:00. The court said they'd be back. We do know that apparently Lucky, the plow driver, is in the building, but we'll see how much longer the cross-examination by Hank Brennan goes and Matt DiSogra. I think he's making the point that all he did was analyze evidence, but the problem is that he analyzed the data without demeaning Burgess in any way in his attitude and the data of Welcher, and showed that the 5 seconds they didn't carry it all the way through. And then if you carried all the data all the way through, he gave you all the possibilities, which is what a real expert should do. Give all the possibilities. The problem is with possibilities, since there's only a 10% possibility in this, that the data stream, that John O'Keefe's phone call ended before the 1162.2 text stream, the data there, that I don't see how the prosecution proves their case beyond a reasonable doubt when there's no collision. And you heard on the motions to get a verdict after the state's case that indeed that was one of the issues that Alan Jackson talked about. No collision. There's simply no evidence of a collision. The prosecution is simply relying on the taillight and her statements. Some of them I think are made up. I hit him. I play no credibility. It's if the firefighters who say that, who didn't have them in the reports at all, especially since she never denies saying, did I hit him? Could I have hit him? And she explained that in one of those interviews, because what happened was that Jed McCabe said to her, well, he never came into the house. But it turns out apparently he did go into the house, according to the defense. Kay Schmidt, thank you for gifting 5 Justice Served TV memberships. I'm sure the members will appreciate it. I think Michael Bryant's been posting some stuff. I've been so busy with you guys and with regular work, I haven't even had a chance to check the Justice Served TV YouTube page to see what is happening on the members aspect. But I know that he normally is pretty good when he's away and doing his thing of posting on it. And hopefully he'll come up with some more answers about Madeline McCann, see if there's anything that's been done. I know we filmed some stuff, was it last year or 2 years ago? Maybe just last year on it, but that's all we did was like film a location. We didn't get really into it because we had to decide whether we were going to get really into it, and then we decided we are. Hence, Michael Bryant in Portugal. Okay, so that's where we are. So let's see. Any other questions that we have here? Let's see. As you know, I did a rant before lunch. We're going to clip it. We're hoping that maybe Jess Machado will come on the show tonight. Because we'd like to see her. And I see
Whenever
that
you're
we're
ready,
back
Mr. Brennan.
just in time, aren't we? I see the fan. There's Judge Beverly Canoni, and she is. And it looks like we're going to continue. So let me be quiet and let's go into court.
Ms. Gilman, if we could turn to page 6 of Mr. DiSogra's amended PowerPoint presentation. Sir, I want to ask you about your opinions, and inevitably, some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition of the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is with the other chips part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report, where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Sustained.
So when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. when you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I
show.
know that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
Okay. The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know, Mr. Burgess actually looked at the data, not just the timestamp. You looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point. It's a derived value from the key on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so
Pardon
they're
me.
not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3 second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3 second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
your
this specific Lexus.
I'm sorry, finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3 second delay. It's a yes or no question.
I'm saying we don't know. Had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3 second variance, you don't have any assurance in your own mind whether or not this car, Ms. Reed's Lexus, has a 3 second variance. That's what you're trying to say.
That's correct. And that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now let's turn to slide 9. As part of your charts, could you enlarge to the left, please? As part of your charts, you took this chalk from Attorney Burgess's report and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m. You said on direct examination, oh boy. You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart. So
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matched to John O'Keefe's iPhone or some other phone matched to John O'Keefe's iPhone? Did you do any independent study about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Is Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m. the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 calls. Do you know where that information came from?
It came from the SD card from the infotainment.
Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. You know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
Okay, so I guess that Brennan's not getting very far with this witness. He's just honest. He knows what he's doing. He's honest. And he's trying to all sorts of ways around it and all. And now he's getting a little argumentative and he's making comments and all. There's an objection. And quite frankly, at some point there should be, because he's talking about what he tested. Oh, they're back already. Okay. That was a quick. In the meantime, let me thank Curious Law Tuber, Gifted One Justice TV, a membership. Thank you, Curious Law Tuber. We appreciate it.
Do you know the genesis, the source of those 4 numbers?
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from the defendant's phone to Mr. Ortiz's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So,
Do you know where those calls came from?
a phone,
Whose?
Miss Reed's phone.
Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, you plug your phone in?
Hank's not near the microphone, which is why it's hard to hear.
Come from the phone. Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure. If there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone is plugged into a car, it downloads the information from the iPhone on the payment system? You know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a part of it you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection,
but
Your Honor. So I'm going to strike that. Go ahead and ask your question.
I apologize. If you have two different devices, a Lexus clock, an entertainment system, and an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, do you agree that you would expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
Two iPhones?
Yes.
No.
So if you sit there today, you don't have any expertise, any education, any knowledge about how closely two iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other? Objection.
Sustained.
Do you have any opinion about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree all of your assumptions and conclusions are inaccurate.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Sustained.
So this is iPhone to iPhone. Then your assumption on the first 5, 12121. If they're iPhone to iPhone and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they? Objection.
I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they? Objection.
Sustained.
At 5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Birch's report as I recall it, in that he stated during the testing they did with the exemplar calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed. There were 2 call logs in Mr. O'Keefe's phone, but only 1 timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
If these are 2 separate calls, can you explain to us why there is 1 timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar vehicle, was it?
This table, no.
No. This information was taken from the infotainment system of the defendant's car. Isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone. Isn't that true?
Yes.
And so, you know why there would be 2 phone calls and only 1 timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Did you know that?
Yes.
Well, if you know that, can you conclude that even though there's 2 calls and only 1 timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's how it works.
So when you look at 530.15, bottom middle, and 530.52, it is impossible to tell which one relates to the 530.31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
I'm not sure I understand the math.
530.31 is 16 seconds different than 530.15 on Mr. O'Keefe's phone. Yes?
Yes.
530.31 is 21 seconds different than the 530.15 phone call. Yes?
Yes.
And the difference is cut each way, one's minus, one's positive.
Correct.
So you add those disparities, you get 27 seconds. Don't you? Objection.
I'm going to allow that.
No.
Okay. What do you get?
You're saying if, maybe, so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
how many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the next card was turned on at 5:07 a.m.? Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable, yes.
But when I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay. If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
If we turn to 10, please. Given, could you zoom in a little, please, on the left? Given that these data points.
Haven't written anything down. I don't know about
at
you.
5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30. Did you consider whether they would be less reliable than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:30, 1:43 to 48, than the 3-point turn?
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy, or would you like me to bring it
Do you
to
have the reports with you, sir?
on.
Okay. Do you have an extra copy for him, Mr. Brennan?
Mine is marked. If you want me to show the mark. Let me see if I can get a clean copy from the witness.
All right, so Hank went somewhere, and I don't know, what is he doing? He's expecting his witnesses, acting like his witness. This is just a great witness. Yes, no, yes, no. I mean, if you want to show it to me. All Hank is doing is reading the report of that.
I don't have a clean copy. I don't want to show you
testified
something
for.
that has my writing.
Oh,
on it. Not that
now
I
you don't
can't
want to
give
show
you,
you
but
something.
it's
Okay,
protocol.
yeah, well, there you go.
Okay.
You pulled your own bluff.
In discussing why this is not an effective way of matching the time, did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes.
And when
Call
he
logs
talks-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 5:30
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see Counselor Tadman.
I think the judge wants a copy of the report now too. I mean, because this is just belaboring. You know what it is? He can't get anything out of this witness because he relied on the data from that Burgess did, right? You know, so if you're going to say Burgess is an expert, let's look at problems in Burgess's data. And now we're talking about the iPhone. So, you know, anyone who has an iPhone knows when you plug it into, for instance, like the CarPlay or the infotainment system in my car, then it's going to sync. It's going to show your call log and sync your call logs. And it may sync your call log. I don't know if it syncs the call logs to when the call was made or to when it reads it from the infotainment data. That's all this is about. It's basically irrelevant because we're talking about the 5 o'clock in the morning calls. We're not talking about the problems that the prosecution has as a result of this witness analyzing the data that Burgess downloaded, which, by the way, was unusual because that's the whole idea. They had a protocol that's usually established and adopted and effectual about the using a certain protocol, and then Burgess gets there. Remember, he's a wizard, you know, according to his. He likes to be a wizard. And so he had decided a new thing. Let me pull out the SIM card. And there's no data on pulling out a SIM card and analyzing that, but that's what he did. So that they're looking at this data, the SIM card that Burgess pulled out, which was not in a protocol that you normally do, and it's never been Daubert, okay? There hasn't been a Daubert analysis on it all, but this is the way it is. And then they only use one exemplar car, so you can't really tell if this happens in all cars or not cars. All we know is that the SIM card wouldn't fit into Karen Reed's car. You know, quite frankly, Burgess's stuff is a mess. But if you want to analyze Burgess's stuff, it was good for the defense the way it ended up because they didn't carry all their 5-second deviations all the way through in time. And when you carry it all the way through in time, it still shows for the most part, with the exception of 90%, that John O'Keefe's car, his phone, was active after the event that we're talking about, the 1162 event.
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean copy?
You can turn to page 3. What I read to you was where it says clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Okay. Because you still are under the mistaken belief that
Sustained.
you still have the opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had. That those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
So if we put up chart 12, page 12, please. If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to 14, please. And if you could enlarge, well, I don't think you can enlarge it. If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the 3-point turn event 11:62:1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea, not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head. He put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
I want to point out the unfairness of this. Remember when Leslie's trying to question Welcher because he used Dr. Scorty Bellows, some of her findings, but not all of them, and also with regard to Trooper Paul. Think about this. He's questioning him on Welcher, okay, and other findings.
Okay. Let's start with 1982B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event, as timestamp 154. That actually is at the beginning of the 3-point turn. Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
Okay. And it notes that.
So ask it differently, Mr. Bowman.
Does that heading note the start of the 3-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the 3-point turn maneuver.
And then the heading of the change, end of 3-point turn to O'Keefe's home, 12:24:07. You have any information to suggest that's not spot on accurate?
I did not analyze the 3-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the 3-point turn conclusion. Did you consider that?
I'm going to allow that, yeah.
I'm not sure I understand the
Okay.
question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the 3-point turn.
Yes.
Based on Mr. Burgess's May 8th report and based on the data, which you don't contest, you now agree that 154 was not the end of that 3-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected
What
by
happened? You can't
either
comment
Mr.
on the
Burgess or Dr.
accuracy of
Welcher.
other
Do you have
witnesses,
any information
expert
you'd like
witnesses'
to add or
testimony?
weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. You could open that. The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Sustained. Strike it.
In the final exhibit? Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range?
Objection.
So ask it differently, Mr.
Okay. You suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates the beginning of the 3-point turn, and then the orange is at the end when the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
Do you have any reason to test the accuracy of this data that's converted? Never objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, wide range, right? Even though this analysis depends on the end of the 3-point turn, would you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the 3-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct?
And so if Aperture's position is the matching times at the end of the event, going back to the beginning, isn't that even more forgiving than the 8 scientific objection?
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
Right. The opposite of cherry picking, right?
Sure.
Do you have an opinion to a reasonable degree of forensic data certainty about whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's 19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
He's such a snake. I'm sorry. That is a snaky way to end. This is a great witness.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen.
What's up, Will?
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
Mr. DiSogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report, the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
There was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would.
Alan will have a chart to give to the witness.
Thank you.
Mike. Hank.
Yeah, there are a lot. I would have to really use my finger to count them all.
Okay, more than 8,
Total after 1162-2.
only on the 29th.
There aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, right?
Yes.
May I approach?
And there weren't, there weren't
Again, this
30
is back to
collisions,
Mr.
that's for sure.
Brennan, I want to follow up on, in no instance were any of those related to a collision, to your
Oh.
knowledge, correct?
Must have been listening to my question.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you.
In other words, a text stream event does not mean a collision, which is what the
I
prosecution.
want to ask you a
is saying.
hypothetical, if I could, based on questioning by Mr. Brennan.
It doesn't
surrounding-
wake in the black box, okay? To use the vernacular.
The 12
And if there were a massive
3209
collision, we would
lock
have
event.
it in
You
the
remember
black
him asking
box.
about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12:32:09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12:32:16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12:32:09 to 12:32:16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after
Great question.
the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis. The hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Brilliant, brilliant, brilliant.
If you were told, let me give you another hypothetical. If you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12:33:14, would that impact your opinion in any way?
Objection.
Sustained.
The judge saw.
You were
Judge
asked
Canoni saw, she allowed one question and she didn't like the
several
answer to that.
questions
So now she didn't allow that in because that would help the defense even more.
about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess,
Hold on.
of course,
You need to, you know, we have to turn the fans off.
and I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you.
What is she talking about? What question? Do you want to go back this
You
morning?
were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the of the text stream data or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch? Click, a stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
As a clock,
Are those two things independent of one another?
completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment or proposing that adjustment can be made because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints.
This
of
is
Mr.
what a
DiSogra's
redirect
PowerPoint.
examination is like. Boom, boom, boom,
Can
boom,
you
boom.
highlight the table on the left, Mr. Wolf? Thank you. Did you create this table?
No,
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
it was. It was a
Did you
screen.
type-
It was a screenshot.
Thank you, screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes,
You didn't type anything on this.
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection. Sustained.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection. Sustained.
I mean, this is ridiculous because, of course, if he didn't create the columns up there, he has a right to assume that, or else Mr. Burgess is wrong and lying to the jury.
Yeah, just a moment,
anyhow.
Your Honor.
Sure.
This is
Do you need the
ridiculous,
light
and
on?
she
I
sustained
don't,
that.
I don't.
I'm sorry.
And we can pull that down.
But I think the jury got the point. I think the jury has the point, okay? I think it absolutely has the point. Blessed in Texas, Linda, do you read
What was
007
your
Texas? I'll
entire
get back to this.
analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to this jury during the course of the day.
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no,
Did you explain their analyses?
yes,
Sustained, ask it differently.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and the presentation to the jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes,
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
that's correct.
You were also asked why you believed Mr. Burgess did a quote unquote more detailed report in May versus January of 2025. Remember being asked that just a few minutes ago?
Yes.
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting?
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
All of them. All of them. All, that means what it was, John O'Keefe's phone was on after all of
So,
the
Mr.
data
DiSogra,
there.
this demonstrates
There you
the
go.
danger
Retrial.
or the difficulty.
Hold on.
There's an objection, sure there is.
Start the
It's
question
cross-examination.
differently.
It is, it has to be a question.
Start. Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data. because
I'm working
you're
off your
relying on
your experts who
studying the data,
testified.
are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, please. When you're
That's what
looking
peer
at
review
someone's
is, by the
report, you're
way.
guessing
Analyzing
as
data
to
that
what
you
the
didn't do
jury thought, I
yourself.
presume, if you haven't spoken
Jerk.
to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides on the infotainment system, correct?
There's a transfer of data.
And
Yes.
so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea. whether
Then
it
all
was
of your
on the
expert
iPhone.
reports are wrong, Hank.
Fair?
That's right. I don't think that's.
And so when you
No.
don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing
Just
that
like you
Aperture did. So I
interpret DNA.
I did not make a
Okay,
guess.
Everybody?
1 through 5, and you telling me right now, with reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself, rather than
Because that's what the chart says, that his experts relied on and testified to.
So,
I am
either
going
you strike
crazy
it,
here.
Ask it differently, Mr.
Yeah,
Brennan.
strike it all right. Strike the whole prosecution.
you wouldn't have to make a presumption that you'd be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Woodson's report?
no,
You don't know if that testing was done, do you?
I don't.
I'm going to let that stand. Next.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
Oh, come on.
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis,
He's got the
then
data
the
from
final
Burgess and
analysis is going to be
Welcher.
wrong. If you have
Okay,
using the
what
wrong
are we
data, it's that
talking
simple,
about here?
Yes.
right? You don't have to be a scientist to figure that out.
Yes. That's,
Okay. If we could have Mr. Welcher's 33.
Oh, take me out of my misery. I don't think I would do well as a juror in this case.
If you could open that up, please. You were asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds, right, in those first couple of lines. Yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving. Yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving. Yes?
At the end of the record, there is a vehicle speed. The car is moving. That would be my assumption.
Okay. And so when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window. Yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay.
Mhm.
And so after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12/32/12, which is in the 10-second window, and 12/32/16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay.
12/32/16 wasn't just that Mr. O'Keefe's phone was moving, but the steps did.
I didn't review the phone data, so I don't know.
Did you review anything to indicate that the steps were taken over the course of 3 years?
Objection.
So that's sustained.
You were asked just a second ago. What about the data? What's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DiSogra, you are all set, sir. So you can step down. I'm going
Okay.
to see counsel for a minute.
She wants to
Joyce,
see
feel
what-
free to stand up and stretch if you'd like.
Yeah, feel free to stand up and stretch. I actually have let me come down here. As we're stretching, I'll read. I have my yoga strap here to do my yoga strap. Oh, let's everybody come on, stretch and read. We've got some time. So, Blessed in Texas. Okay, $5. Linda, thank you very much. Did you read the 007's Texas, I think, calling DiSogra dashboard daddy a while ago? Perfect. Sorry, I called out the wrong person. Oh, I like dashboard daddy instead of crash daddy. Okay. And there you go, Blessed in Texas. JSTV, Justice Serve TV at Linda. Is Hank violating any ABA professional rules of conduct in his questioning of DiSogra? No, he's not, because the judge is allowing him to do it. The judge is allowing him to do it. You know, that's what's happening. But I don't think it went well. I mean, the whole point of questioning if this data is wrong, if it's not the infotainment system and it's the iPhone, it's wrong. That's what their reports say. That's what they testify to. So if their data is wrong, which it could be, because remember, taking things off the SIM card had not been done. That's not anything that's been Dahlberg tested before. It's what. Let's stretch some more. Come on, let's stretch some more because I'm getting aggravated. It is what Burgess talks about in his Burgers and Bites Twitter account, that he's got this new way of doing it, and it's a wizard, and who doesn't like to be a wizard? And that's what she didn't give him a Dahlberg hearing with regard to that there hadn't been any testing off SIM card, because the protocol that they had agreed to and was established when they got to the exemplar card, because that's why you hire an expert to go follow around and see what's happening, right? That's what they agreed to. He changed it and decided to do the SIM card. Okay, and then it comes in and with the SIM card data. So with even regarding the SIM card data, if the SIM card data is there, it was wrong, it was off. Okay, but what this expert did is say, okay, but I'm going to take what they take as the end event, and I'm still going to show you that John O'Keefe's cell phone. By the way, at least 90% of the time he was still alive and using it, or it could be 100% of the time.
Now or not, and I'm going to let you go home. So that 5 minutes that just means that you get to go home, because we know we'll be longer. We don't want to do this to you. Okay.
They're going to be an hour dealing with something.
Break for the day. I have to give you those same
Okay.
cautions.
Well, we'll have to see what hour they're going to be dealing with something now.
Research or
Oh
investigation
boy.
into this case.
I wonder if she's going to give a nature break to the participants in the courtroom.
The additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. We'll start
So we
right
say.
around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise to the jury.
So they say. Okay. So I know there's people on line who think that Hank Brennan's cross-examination style is good. Yes, it's good for a defense attorney. That's what he's used to doing, poking holes, attacking and all. And that is a very good style, right? But I don't think he made DiSogra look bad at all. I think DiSogra was
I'll come
great.
back in 5 minutes for the voir dire.
Okay, come back in 5 more minutes for the voir dire. I wonder who this witness is. Maybe we can look on Twitter and see what voir dire of the witness is needed. Boy, we're so easy to give a voir dire, by the way, we're easy to give the voir dire to the prosecution, aren't we? When the defense asks for a voir dire, you have 5 minutes. You don't have an hour, you have 5 minutes, 10 minutes. How long are you going to be, Mr. Alessi? How long are you going to be, Mr. Jackson? Oh, boy. Oh, boy. Oh, boy. Oh, boy. I'm glad we're all going to have a weekend, because this is just ridiculous. So let's see if we can find out who the next witness is. I'm looking on, see if there's anybody on Twitter, X-Twitter, who knows. Let's see. Hold on a second. Well, that's what I thought. It was Lucky Lauren, because he was in the building, right? But why would she need a voir dire of him? That was my question. Why does she need a voir dire? What is going on that she needs that she's giving the prosecution a voir dire of him, especially since he testified into the first trial? So that's what I thought, because he was in the building. And I figured that's a perfect ending for Friday. He's a shorter witness. He's not an expert. You follow with a great witness. You follow with somebody who didn't see the body. But I don't understand now why they need a voir dire. Is there some indication that he's seen part of the trial, that he's talked to part of the trial? I don't know. All I know is that to me, there seems to be a disparity of who gets a voir dire and who doesn't get a voir dire. Okay. I mean, Shannon Burgess, you didn't get a voir dire, right? You don't get a Dahlberg hearing on him. And look where we are with regard to this. Okay. Am I shouting? I'm sorry. Am I shouting? Dizzy says I'm shouting. Yes, I'm probably shouting. You know why? Because I am really, he's talking about Hank, but I may be shouting too. Okay. So if I'm a little loud for you, tell me, because I just find, I find this whole thing And I don't know about you. Yeah, Will, can you pop on? Do you think you can pop on since you're here and we're waiting? Will, yeah, let's, if you can, Missy will send you a link. If you can pop on, let us know. Here, let's see. I got to find you here. I know you're there. Will, it's likely lucky. I'd love for you to pop on for the few minutes that we have here going on because I am, there you are, right? He's in the courthouse, right? Like the plow driver. That's who I thought would go on. I just don't understand why why the prosecution needs a voir dire instead. And you know what? It takes away the whole defense's rhythm because they expected to have DiSogra and they expected to have the plow driver. And what a way to go into the weekend, right? DiSogra showing the information. Everyone wants Will. Everyone wants Will the Glare. Everyone wants Will the Glare to come in. So, Will, if you can come in, you know, come on in. You know, come on in, please. I don't see an answer yet to there. So, you have. Let's see if we can try to get him. Yeah, I turned. Okay, my mic was turned down because court was so low. Does that mean I have to talk louder? No, I thought it was because Hank Brennan was shouting, although he wasn't. He obviously moved his location strategically to be in front of everybody because he didn't stay at the lectern where there is the microphone. So my volume is good. We need Will. We want Will. But the whole point of now what's happened is the defense had this whole put up. We put up you know, DiSogra, and then Hank spends an hour with this ridiculous cross-examination, more than he has. Okay, Will, I really wish I could. I have a life of my own in an hour, and I'm moving at less than half speed. You have a life of your own. Life or live. Okay, well, we'll get you next time. We'll get you next time, okay? We thank you for popping in. But so he disrupts so he does this and he then disrupts the defense and now he wants a voir dire. And so instead of the defense going in with the two witnesses, which they were expected, they go in with the one witness who I thought was still good, but I'd rather have Lucky Lauren. I'd rather have somebody from the community in, the plow driver who didn't see a body very clearly, looking on the sides to be careful at 2:30 in the morning. Okay, let's see. I'm going to pick a couple out here just so. Thank you for inviting me on. We'll set up something soon. Yes, I hope so. I hope so, well, because it's always a pleasure. And you know that Michael Bryant will be there next Wednesday and Thursday as it's planned now. We'll see. I'd love to get a report. I saw some pictures about what's happening in the buffer zone, which as a result of everyone, including Michael's lawsuit and all. Let me just put this up only because it came through. MLH timeout. Walsh was flailing his arms all over the place. DiSogra is just calm and cool. I thought he was very, very impressive. Yeah, I thought he was extremely impressive. He didn't get rattled. And he said, look, if you're going to assume that, you take these lines out. But what is Hank going to say? That his people were wrong? I mean, this was like, it was like, there's a game called 3-Card Monte, you know, that they played in New York, and you bet, and and all, and it's just a game. It's a game, you know, and again, Hank Brennan has a defense attorney's cross-examiner style. He keeps going at you and at you and at you. In a way, he and Alan Jackson are matched pretty well with regard to their cross-examination style. I just don't like it when you are. It's one thing when you're a defense attorney, you're supposed to poke holes. You're supposed to do that because you have to keep the state to the burden of proof. But when you're acting as a prosecutor, and here he's a special prosecutor, you have a duty for justice, not to make things seem that they aren't, okay? You're supposed to bring the truth before this jury, not to make things seem that they aren't. Let me repeat that. As a prosecutor, you're supposed to bring the truth before the jury, not to make things seem as they aren't. And defense attorneys, we're used to this. So why I say to you, he's got a good cross-examination style, but his cross-examination style is really one geared to like somebody who would represent Whitey Bulger, okay? Put the government to the proofs, and we're going to poke holes and all sorts of things. And so, don't underestimate him, though, because it could be the jury has that effect. Oh, the defense only needs one person, as you know. The prosecution needs all 12 people. Okay, so do they have a voir dire to see if the witness is pleading the fifth? Excuse me, let I yawn. Oh, I'm so tired from Hank. He's putting me to sleep. No, just kidding. Okay. Thank you. This is the class, Leon lately. Congratulations, Leon. Is it Leon or is it Leon? Since I actually called you out. I was on live when you gave the right answer. Thank you. It's the classiest legal show in crowd. I'm so happy. Jason Grant. Jason, you're here. Good. We got good crowds. I'm outside the court now. Woo! Thank you for reporting for us. And thank you for coming on last night, too. Thank you for being. The case is going to go down as Grant versus, the Commonwealth of Massachusetts, Judge Beverly Canone. You are famous forevermore as the name of your case and all. And Jason's been on our show. I'm sorry, I made everybody yawn. I was like, effect. Hank was like, oh, Hank, oh, dear, I'm yawning. Okay, just like that. Tubi the Poodle is also a greeting. Yes, Hank, it's like, come on, Mom, come on, play with me. I'm supposed to, be your service poodle for your replacement hips, and I'm up here and you're down there. Because Tubi, I would not. There he is in the corner. Our Tubi avatar. I would not subject you to all of this. Okay. Colin Six Hitter said, to be fair, Hank may have talked loud because of the air conditioner. At one point, he talked loud, but at one point, he talked very low. And that seems to me is because he was away from the lectern. And I don't know why he was away from the lectern. Where was he standing and all sorts of things. So let's see. His question, they have a voir dire for a witness who pleads the fifth. They do. They do have a voir dire, but I don't think Lucky is going to be one of those unless there's somebody in court. Excuse me, do I see Michael Proctor? I saw somebody say that Michael Proctor couldn't plead the fifth on testimony he already gave. He actually could plead the fifth on testimony that he gave. Okay, just so you know. He can plead the fifth on that because if there's something in there that was improper or false, then there's an issue of perjury. So yes, he could plead the fifth on testimony.
You are unmuted.
Oh, here we go. All right, let's find out what this is about. The poor court reporter. Did you see her the other night? Oh, God.
Was now open, maybe see. You solemnly swear the evidence you give the court in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God. Thanks. You take the stand.
Thank you. You're welcome. I know this is a welcome opportunity. There is in this house.
Sure. Is she right outside the door? Do you mind, sir? If you can stay right there.
Sure.
And it'll just be a few minutes, okay? Ms. Giannetti, when do you need this witness back? Monday?
I don't know who this is, or else I would tell you.
So I'm going to need her at a microphone. Do you have one on council table there? So the podium, or one of those.
Sounds like
thank you.
that there's an attorney for the witness who's on the stand. I can't see who that is, and I didn't hear.
No, there's a microphone a little closer. Just follow the.
I could be wrong. They said the judge said we're going to need a microphone for her.
Hi,
Sounds like
good
a different
afternoon.
attorney.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day.
Yes.
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here.
Yes.
All right. So that summons is still good until we reach you.
This is the
So you don't have to come
prosecution
back
had
Monday
moved
morning,
to.
okay?
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay.
don't know.
Thank you very much.
Eliminate her
We'll see you Monday
testimony.
morning. Be here before 9. Okay.
Defense noticed that
thank you
they
very
intend to
much.
call
Thank you, Your
Kelly
Honor.
Denver as a witness. And the Commonwealth moved for all sorts of
Go ahead, Mr.
communications in a
Leslie.
motion this morning for reciprocal discovery. So she's going to come back. So now we're in a voir dire.
Big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this old guy.
Can we turn off the fans and the air conditioning? Are they all off? We're just going to do that, sir, so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduate high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes,
I would like to show you a document, sir, and I'm going to ask you to read it to
Commonwealth
yourself.
filed a motion to
Familiarize
prevent
yourself with
inadmissible
it,
hearsay,
then
and I
when
think
you're
this is
done,
one
look
of the
at it.
witnesses
Okay.
they
May I
want to
approach?
prevent from talking to the jury. I filed that motion this morning, by the way.
Would you like this marked for identification first, Your Honor?
Yes.
Remember, the jury is not here. This is a voir dire.
thank you.
Because of this motion that the Commonwealth filed to preclude the hearsay coming from this witness. By the way, Will says that Kelly Denver is it's Deaver by the defense, Denver by the prosecution motion. Boston cop, former Canton cop, and Turboy did a story about her having something to do with the tail light. Ooh, I've got to look into her a little more, and that's why they got added. She was added to the witness list, and all. So I imagine that we'll end up having a voir dire on Monday too. Thank you, Will. Jason says, let's go, Will. No, Michael's not coming on this evening. Maybe 2B, but not Michael. Michael Bryant will be on along with Lauren Conlon to talk about Diddy at the last part of the show.
I think he's all set, Mr. Newman.
Thank you, Ronald. Sir, have you reviewed that entire document?
Yes,
Does that look familiar to you?
yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years, definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Well, do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes,
So as of January of 2022, you would have had a passcode to get into your phone, correct?
correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to.
Sure, I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you type. Oh, I'm sorry. It's for the record. It's on page. Oh. And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
So, yeah. So let's not, if he recognizes, I don't want to put names out.
Oh, I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes.
Why don't you refer to the last 2 digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment.
Yes.
Yeah, of course, of course. Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
Yeah.
of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
Just one more question for you, sir. Does the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right. So, sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay. Thank you.
Your Honor, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right. Sir, you'll make sure your client is here when we need him?
I told you that he
All right,
had
thank you.
counsel there with him because I heard the court say you have to give her a microphone. So that usually means independent counsel.
He's been very cooperative.
Not sure why he needed counsel, but
Thank you.
All right. And thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
sounds like the judge is going to allow him to testify against the to the jury since Monday first thing.
All right. We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I've got to respond to the objection.
I want to hear you as to why this is admissible.
Well, didn't she just say he's coming back Monday first thing, probably? Now she wants to know why it's admissible? I know you're all frustrated. I'm doing my best to explain what's happening. I can't tell you why it's happening this way.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the
Yes, the
these actual
massage
emails, not
parlor
text
makes
messages.
its
Any of the
way
emails that were
into
admitted
this
into
case.
evidence, nobody saw him do it. Nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a longstanding rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in again because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement. So the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Baden defense or present a Baden defense. That case had nothing to do with Baden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Baden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Baden issue and you can't use hearsay to present a Baden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Baden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Baden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's gonna go down for this. We're gonna pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you,
All right.
Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in some substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias, because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant?
In other words,
Is it
Hank wants to
material?
force them
And
to
what is
call
the
Proctor
value
so
of
he
it?
can cross-examine Proctor
I am not
and say,
opposed to the
you're really a
admission
good cop. Here's the reasons
of
why she
bias
killed
against a
John
witness,
O'Keefe.
especially a police officer.
That's what's going
But
on
it should
here.
be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of finding the value for which this is being omitted. I do have some issue that it's really not under the context of Baden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side, because it will lead to
He's so worried about being unfair
it
to
will
the
lead to arguments
defense.
about what
Ah.
it means without a factual basis. And so my position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Telling you, that's what he
Dave, do you wanna
wants.
respond?
I know we're the hours late, Your Honor. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine
cases. I
which
know this
witness
stuff.
we want to use to authenticate and admit text messages. That's our choice, and we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument.
That's why you
is
come to here,
entitled
listen to us.
to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay, and just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages.
So we will
What
have a
we heard,
decision
Mr.
on
Brennan?
I thought
Kelly
you were
Deaver
standing
before
up, Your Honor.
4:30.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
Okay, so we have a decision on Kelly Deaver at 4:30, and she is she was working as a Canton police officer on January 29, 2022. There's a radio transmission. I got this off the internet. Purportedly from the morning John O'Keefe's body was discovered of Lieutenant Paul Gallagher calling her and saying that an unnamed Canton police lieutenant, PD lieutenant, wanted to see what address on Fairview Road the first responders had arrived. She told him 32 Fairview. So so now they want all communications, reciprocal discovery, And what the defense is saying that they didn't really have emails or communications like that with her. And if they did, I guess they're going to have to reduce it to writing. So let me just answer your questions because we're going to be back at 6 o'clock. Okay. Linda, will Hank try to force Karen to testify in the way he's with Proctor? He can't, and he's not going to force her to testify. It ain't going to happen. And that will be shut down by the court because that is absolute reversible error. So thank you for that question, Shy Gal. Okay. Elliot Jamison, I'm sorry. Elliot Jamison, he testified in the first trial and must testify in this trial. He cannot plead the fifth. Yes, he can. He can plead the fifth because he may have lied in the first trial, and therefore he has a right to plead the fifth in the second. You don't waive your right just because you testified in a trial to then decide to take the fifth in a second trial. I know there's been a lot of discussion on that, but the impetus could be the fact of whether or not you said anything that was false in the first trial, and therefore he can take the fifth at this point. All right. Even though he's not been charged with the crime, you don't need to be charged with the crime to take a fifth if there's a possibility that there is a crime that you know you have committed. Okay, so that's with that, Sam Poop. Let's ask Linda. Linda, why wouldn't defense want jury to hear Proctor on the stand? Seems odd to me. He's lead investigator. I thought initially they may have to call. First I said they didn't have to call him, and I thought maybe they did. But if they can get the text in, I wouldn't call him for the exact reason that he just said. They want him on the stand so that they can do Hank's cross-examination of him, but it won't be a cross. It'll be, and let me explain why you did this, and you did investigate, and this is why you thought she was really guilty, blah, blah, blah. And he could explain away. But if you get the text in through another matter and they decide they need to call Proctor, you force the prosecution into calling him, which I don't think he's going to come for the prosecution. I'm probably, he's out of state somewhere at this point if I were, and avoiding a subpoena. So I don't think they want to call him. Colin, 6-hitter. Yep, Hank has told Proctor to take the fifth, and now he wants to keep the text out. Yeah, he wants to keep the text out. Yeah, absolutely. There's no doubt about it. And she may allow it, although, with Deaver, she said, I'll see you Monday morning. So I assume she's going to allow Deaver in. She may want to keep the text out. It'd be outrageous because Yanetti's right. Most of the texts are when the prosecution's trying to get them. Here, the defense can authenticate them, and they are valid. They go to Proctor's bias as a lead investigator, and he wasn't called, and they go to the whole Bowden defense. They're absolutely intertwined. But I don't expect that Judge Beverly Cannoni is going to make it easy for the defense. She may say, no, you can't. Well, you've got to then call all 4 people that are on the text. You've got to call everybody to validate the text. That's just bullshit. But you know what? We've seen so much bullshit in this trial. It's a legal term now in this trial. There should be a coined a legal term. Bullshit. Karen Reed trial. Okay. And all. AJD09FB. What are the odds that she will refuse to allow them near certainty? I think she may refuse to allow them to come in. She's gonna, when she says, I got to research it. Well, this should be an easy call. There's no more research needs to be done. The defense has authenticated at least one person who can authenticate all the rest. They're relevant as to bias. Even Hank Brennan said they're relevant as to bias. Bias, he said they're not relevant as to Bowden, but they are, because if you have bias, then you're not doing a proper police investigation. But she's going to find some reason maybe to deny them. I mean, it could be coming, and I'm sure the defense expects it. Paula Kelly, shoot, I need cliff notes on what's happening. My daughter is interrupting me. The cliff notes on what's happening is we had Matthew DiSogra testify for the defense today. He was an absolute home run. The redirect on him, quick, concise, to the point. Here's what you found. If anything you found is wrong, it's because you're relying on their information. And by the way, if their information is right, you give most conservative estimate, at least 90% of the time, you had to conclude that John O'Keefe's cell phone was active after the text stream event, which does not mean a collision apparently. And if you change one thing on it, 100%. If the Apple iPhone of John O'Keefe had walked up 3 flights of stairs or down 3 flights of stairs or show activity at this point, then 100% of the activity occurred on John O'Keefe's phone after the text stream event when he was alive, just like in the first trial. All right, let me see here. Glara, we put on before, we put on well, and I just told you about the Boston cop. Debbie Pelham has 2 questions. If it's not, how will Proctor even be brought in, or the vile text message? Well, then the defense has to try to serve him. And if he's avoiding service and he's in Massachusetts, he's not unavailable. If he leaves the jurisdiction, then he is considered an unavailable witness, and you could actually read his first trial testimony, but you have to read all of the trial testimony. Okay, and you've got a second, Dizzy, if he's out of state, how will they be brought back across state lines? Well, he can volunteer to come, but they can't subpoena him by forcing a subpoena. Like if he is in New Hampshire and he stays there, a Massachusetts subpoena will not work unless you go to the court in Massachusetts and you get a material witness subpoena. And there's a process, there's a Uniformity Act, and then you have to go to the court in New Hampshire. I'm just saying if it's New Hampshire, and then you get them to issue a subpoena, and then you can go try to serve that subpoena for him to come. Okay, so that's how it's done. There's a process on it. It's done all the time in civil cases, not usually done in criminal cases. Blessed in Texas, Linda, is the only reason one pleads the fifth not to incriminate oneself. In other words, one is guilty of something if one answers it. No, not necessarily, because people take the fifth who aren't guilty of anything, but they're worried about the prosecution thinking they're guilty of something or possibly charging them. So you can take the Fifth Amendment not to incriminate yourself on anything you think the prosecution could charge you with, and that could be anything. I mean, we've seen it with witnesses that are helpful to the defense, right? So that's why you plead the fifth on it. Blessed in Texas, we just did that one. Okay, so let me see. I think there's two more before I'm going to let you go. Kay Lola, they should allow to call the FBI agent that pulled the text because they came from the federal materials. I really think they should be allowed to call to say that ACA was hired by the Department of Justice. I think that becomes very important as to their credibility and all. But the judge is not allowing that. Okay. One-sided things go here in this case, but we're used to it as defense attorneys, by the way. I know that you think this is abnormal. This is not abnormal. This is the way it usually goes. All right, Laura McLeod, how could Brenner rehabilitate Proctor if the text of Sally report he was fired because of his handling of the case also would not demonstrate to the jury Proctor is not dead? Well, I think that you can have this witnesses on the text to say they know Proctor is not dead. Okay, because somebody has to show that he's not being called as lead investigator, that he didn't die, he's not terminally ill and cancer under life support in a hospital. But I think they can get around it with one of his friends who've seen him. With regard to handling, he was fired for handling because he embarrassed the state police because of these texts, not because of actually an inadequate investigation, okay? It was because of these texts alone, not because of an inadequate investigation. Let me repeat that. He was fired because of these texts, not because of an inadequate investigation, and he embarrassed the state police. So they could say it wasn't so much the handling of the case, it was the fact that he made the state police look bad by these texts. So, if you think that Karen Reed did something wrong, it's easy in the mind of some jurors to possibly rehabilitate it to say, look, he'll say I made a mistake. I apologize for it. I lost my job for it, but the rest of my investigation was damn fine and blah, 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 blah. So that's what how they try to rehabilitate him. And then, oh, by the way, on the Sally report, I was there, but I had nothing to do with the inverted video, because their whole defense on the inverted video is that it's always been inverted, which is, in my opinion, just not right. Not because of the way the first trial went, but the jury doesn't know about the first trial, right? They don't know that Yuri Buchanan testified on the stand for a whole day about that Michael Proctor never went past the taillight. And then it turns out with the inverted video, he was right at the taillight because the video, it was inverted and he was right at the right taillight, not the right one, but the right one, but the right taillight at the same time. So that's what we have going on here. I know it's a lot. I know I've been going very fast on these questions because we have a show to do at 6 o'clock with Michael Bryant. We're still trying to get Jess Machado on. If you're on Twitter, okay, go and ask her to come on our show. We extended an invite. I don't know if she's gotten it, but I have to tell you before you go, we have so many people watching. If all of you subscribed right now, we'd put us over 14,000. Okay, and that would be really helpful. So it doesn't cost you anything to hit the like button, and it doesn't cost you anything to hit the subscribe button, which would be really helpful to Justice Serve TV. I remember we're one of the people that first brought the suit, along with Jason Grant and his two plaintiffs, Tommy DeRosa and Michael Bryant, and then Mr. Delgado, to get that buffer zone, undone in some way, and it is undone in some way. It still exists, but you can actually use your First Amendment constitutional rights to go protest it. And without, we were on the air. We're the ones who recorded it on the air. We got it right then. I was on the air at the first time that it happened, the first day. And so, it's nice to support a small network like ours that's trying to go so we can bring you these trials. Because if we have to go flying out to Florida for Donna Adelson, and if we have to go to Oregon for Koberger, well, you know what I'm saying. It gets expensive, and at least if we get into that subscribe button, we get more ads on the channel, and then hopefully we can fund at least those costs so that we can bring this to you. Anyhow, we love our subscribers, but I'm going to ask you if you would please hit that subscribe and like button right now. And at 6 o'clock tonight, that's only about an hour and a half away, we'll be back on the sidebar with Michael Bryant, who is in Portugal investigating the Madeleine McCann case. Hopefully, Jess Machado will come on if she gets our invitation to talk about the rant I did this afternoon about how women are under attack in this case in the Karen Reed case, whether they be reporters, whether they be defendants, whoever they are. The expert witnesses, they're under attack, in my view. And then also we'll have special guest Lauren Connon on, who's been in the Diddy courtroom since it started, and she's going to give us a report on what's happening in Diddy. And you won't want to miss that, because I'm sure it's things you can't imagine you would ever hear about in your lifetime. All right, so everybody, lights out right now. See you all. We're already portaled into the 6 o'clock show. Okay, and I just see that Micro Dots put out a new video. By the way, go to our merch store. You get this. I'm going to order my camo one today. There's also a beautiful pink one, pink and green. There's also a beautiful green stripe one. This is the, as you know, the hoodie. All right. I should be treating it a little better, but I have it here to show you again. And also a Microdots, support them with their merch store, because it's because of their merch store that Erica Walsh was arrested, because she was wearing their merchandise. So all these little products help everybody who are LawTube streamers and who are reporters and journalists. And maybe someday Massachusetts will remember us, accept us, because to accept us, they're accepting you. Anyhow, like, subscribe, share, notify. I'll see you in an hour and a half.